Good morning, everyone. We are short of a speaker, but enough to get started. I think we can very much rely on the first setting the scene session and already the second session. We have some ideas within which we can insert the debate today, to which I'm most grateful to Professor Lucia Rossi and Professor Federico Casolari for having kindly invited me to take part and benefit from this very stimulating debate. From yesterday's suggestions, I take that we can join in a debate whereby rights, values, and trade would seem to an old-fashioned or just old lawyer something which is interchangeable, entangled, and very much subject to interaction within the old-fashioned approach of balancing rights, whereby rights are the protection of interests and values. Trade is a set of obligations and rights, but I learned yesterday that it is, or perhaps before yesterday, that it is a value in itself. So how do we combine and balance? But at the time of sovereignism within states, and some kind of sovereignism certainly within the European Union, then balancing may clash or go to the extent of compatibility. And it is interesting to see that compatibility sometimes prevails, incompatibility evaluations tend to prevail over balancing at the stage of interpretation and application, but we are concerned with lawmaking in a way because treaty lawmaking is part of lawmaking. And the good news that I managed to disclose this morning is that my BBC application on my smartphone suggests that Donald Trump is reconsidering the abandonment of the negotiation of the TTIP. So the man is surprising, sovereignism is oscillating, and it is against the auspices of changing from worse to better that I am pleased to give the floor to Pia Acconci, who will tackle the relationship between values, rights, and trade in relation to investment chapters in free trade agreements. And without further ado, since everyone knows in the room Pia Acconci, I give you the floor.
Thank you. Thank you, Attila. I would also like to thank the organizers, in particular Professors Rossi and Casolari, for selecting my proposal to talk about the inclusion of the right to regulate of the host state in the regional trade agreements, in particular in the European Union post-Lisbon trade agreements. I will begin with a few remarks on the reasons for the inclusion of a specific clause on the right to regulate in recent international investment trade agreements, in particular in the agreements signed by the European Union. Then I will move on to relevant trends in this regard that we can detect, identify from treaty practice and arbitration case law by focusing on the particular active approach taken by the European Union Commission. And then I will look at the connection that we can establish between this trend towards the inclusion of the right to regulate and the promotion, at least, or better, the safeguard or certain public interest. Then I will conclude with a few remarks on the reasons why, in my view, a multilateral approach will be desirable in order to better coordinate and, if possible, integrate different values and interests at stake. So looking at the reasons why we see that a specific treaty on the a specific treaty clause on the right to regulate has started to be included in regional trade agreements, the main reasons are the case law due to cases brought about by claimants to enforce the treaty clauses on the fair and equitable treatment standard that are usually included in investment treaties in order to enforce the legitimate expectations on the stability, coherence, and even predictability of the domestic legal frameworks of the host respondent states. These claims have been objected by a few host respondent states within case law, and host states have claimed that the alleged legitimate expectations of foreign investors should be counterbalanced by possible legitimate expectations of the host states as to the stability of the political, social, and economic framework. If we look at the cases, we see that the issue of the clash between the fair and equitable treatment standard clauses and the host state regulatory power have arisen from cases due to regulatory measures taken by host states during the life of a foreign investment for the access to water by the local populations, for the management of waste sites, for the prohibition of harmful substances, or for the protection of archaeological and religious sites. So from this case law, we can infer that there is a need to balance the protection of foreign investments that has been the main reason why international investment treaties have been concluded, and a large number of investment treaties have been concluded so far, and the need of safeguarding the host state's regulatory space. This problem of finding a revised balance is due to the fact that we still have in international law regulatory diversification. So we have this attitude by states and also by the international organizations to regulate through different separate legal instruments different issues and different values. And another problem is that over the last 10 years, we have seen a different attitude by certain states, in particular also by certain economic advanced states like Canada or Australia, in relation to the main aspects of the international regulatory and policy framework, because of this legitimacy issue that has arisen from case law concerning the clash between the protection of investment and the protection of the host state regulatory space, and also from political demonstrations. The issue of the legitimacy of international investment law has arisen from the alleged lack of transparency and openness in arbitral proceedings, in investment treaty-based arbitral proceedings, as a reason from expectations for the preservation of a host state's regulatory capacity in pursuit of certain public interest, and from certain expectations related to the accountability of this framework. Looking at the trends, the relevant trends that we can infer from recent treaties and quite recent case law, we see that in certain treaties, in particular in certain European Union free trade area agreements, so treaties concluded and signed after the entry into force of the Lisbon Treaty, we find a different semantic approach to the clauses on the fair and equitable treatment standard, so a different language in order to establish this revised balance. For example, a new, let's say, clause might be this. This is an example that we find in the Free Trade Area Agreement between the European Union and Singapore that was signed in 2014. From reading this clause, we see that the implementation and in case enforcement of a fair and equitable treaty clause has been connected to certain general principles such as good faith, due process, proportionality, we might say, and the manifestly arbitrary conduct that can be seen from the double perspective of a host state and a foreign investor. Then we see this new trend of incorporating specific clauses or provisions on the right to regulate, referring to open-ended list of legitimate possible public objectives. And I have a few examples like this, that is the preamble of the TPP agreement, the other mega regional agreement, trade and investment agreement, that was signed in 2015 among a number of Pacific states. At the beginning, the United States was included. Then we know that on day one of its administration, President Mr. Trump withdrew the participation of the United States from this treaty. And we find a relevant reference to the right to regulate in the TPP agreement in the preamble and then in a specific article, that is Article 9.15. And here we find a reference to specific public interests, such as the protection of the environment, public health, or other regulatory objectives. So since this is close, we can infer that the reference to certain public interest as a legitimate public objectives is usually considered as an open-ended list, so without a narrow-minded or approach. And this clause from the treaty agreement between the European Union and Vietnam, signed in 2016, is another example. Again, we find a reference to legitimate policy objectives as the reference point in order to establish when a host state has this right to regulate without having to compensate in case of a possible regulatory measure that can be detrimental to the interest of the foreign investor. And once again, we find an open-ended list because of the expressions such as, and the reference to public health, safety, environment, public morals, social or consumer protection, or promotion and protection of cultural diversity. A similar provision is included in the draft investment chapter of the text of the TTIP that was proposed by the European Union Commission in 2015. More or less the same provision, and an additional provision relating to the possible legitimate policy objectives that might exclude the application of treaty provisions on expropriation. So a clear, let's say, message to the possible still pro-investor-oriented regulators as to the framework, the international framework on investment. Then we find many times, for example, in many Canadian investment treaties, because of the model BIT adopted by Canada in 2004, this particular provision that is a sort of carve-out that has once again preserved the host state regulatory capacity in pursuit of a certain legitimate public welfare objectives, more or less the same, public health, safety, and environment, in case of the adoption of a regulatory measure during the life of a foreign investment. And this is a clause that we find also in certain European Union treaties, such as the TTIP, the CETA, but also, for example, in the free trade agreement between the United States and Australia that was signed in 2005. Then we have relevant trends in certain arbitration case law, such as the case against Canada brought by this company that was an American company, and Metanex against the United States, and then the quite famous for people engaged in studying and researching this field of international law, the Philip Morris case against Uruguay. In all these cases, the arbitral tribunals have recognized that although the language of investment treaties, the applicable investment treaties, was pro-investor oriented, so was in favor of the maximum level of protection in favor of the foreign investor, the host state still could regulate, could exercise its policy powers for the protection, for example, in this case of Philip Morris against Uruguay, for the protection of public health. So what can we infer from investment treaty practice and arbitral case law? That we have inconsistent results, so still inconsistency, but an increasing importance of certain public interest, a reorientation of investment treaty practice, sometimes, to some extent, more transparency and openness in arbitral proceedings because, for example, the admission of amici curiae briefs, and so a sort of shift in the nature of arbitration proceedings based on investment treaties from a private law dimension that was typical to a public law dimension. And speaking of a public law dimension, the inclusion of specific clauses on the right to regulate that are connected to the protection of certain interests that can be considered public is itself, in my view, a relevant trend towards this public dimension. So a public law dimension, someone would say. But it's still something different if we compare these trends to the past and to the typical approach, orientation of international investment law. These legitimate objectives that we find mentioned many times in recent investment treaties are public because they reflect the interests, concerns, needs of local populations, sometimes of non-governmental organizations that submit amici curiae briefs, of consumers, stakeholders, and the public opinion in general. So from these trends, we may infer that international investment law is becoming the outcome of the interplay of a variety of actors, private and public, interests, expectations, and legal sources. So, going to my conclusions, my first concluding remark is that I still see that a multilateral approach would be desirable to balance the different interests and concerns at stake. Despite the attitude taken by this administration, for example, in the United States, or other possible approach, political attitude of other important international actors, players, I still think that a multilateral approach would be desirable because would revise the legal and policy frameworks together, or at least might coordinate international treaty obligations by harmonizing, integrating different public interests, at least as treaty exceptions, carve-outs, and safeguards, would promote balanced implementations of clauses on the fair and equitable treatment that are still important, and these new clauses on the right to regulate. And so in the end would help arbitrators, would prevent possible normal conflicts within arbitral proceedings, and would even reduce lengthy arbitrations when public interests are relevant to settle a case. So a multilateral approach would be a sort of a step back to the spirit of the ICSID Convention that was concluded in 1966 within the World Bank Group in order to depoliticize the international investment climate and promote foreign investments, in particular from north to south. So this is still a relevant need, and depolitization is quite desirable these days. At the same time, looking at the European Union approach, we might say that the European Union is committed to multilateralism by the treaty. We find this relevant provision in Article 21 of the Treaty on the European Union, paragraph 2, letter H. And so the European Union is committed to promote an international system based on stronger multilateral cooperation and good global governance. So going to the last remark, I believe that a multilateral approach, of course, might be based on new negotiations for a multilateral treaty, but this might be a quite demanding goal nowadays. So, would it be enough to promote state consultations, to adopt possible model clauses, guidelines, interpretative guidelines in particular for arbitrators, for example, in order to reconcile possible conflicts and so to cover recurring issues for the prevention still of normative conflicts, because this is the main issue, the conflicts of norms that we can infer from case law. And then another possible implementation of a multilateral approach would be to promote networks among various researchers and stakeholders. And this network that today and yesterday has organized this important, useful workshop is a useful example and a good example of what might be an implementation of a multilateral approach. So, thank you very much once again for this opportunity. Thank you.
Thank you very much, Pia, for singling out the multilateral treaty lawmaking approach to the quest for balancing the foreign investors' private interests with the host state's public interests, and for showing how, against the fragmentation of international arbitration in the field of investment, despite efforts to enhance transparency, introducing even counterclaims, sanctioning wrongful conducts by investors to the extent of excluding the admissibility and of claims, or even the jurisdictional competence with regard to investment attained or carried out in breach of basic public interest concerns. This leads inevitably to uncertainty and predictability when it comes to just individual interpretation by individual arbitration tribunals. And the message that comes from this treaty-making policy promoted by the European Union goes in the direction of multilateralism, in the direction of permanent court of investment, that we all know about that, which is precisely aimed at that concern, together with incorporating the old United States policy powers doctrine into the power to regulate, which would eventually lead to accepting expropriatory measures of a non-compensatory nature. Without further ado, I'll give the floor to the next speaker, who is Sophia, I suppose, Paulini, who will tell us about environmental provisions in the chapters on trade and sustainable development in the European Union and foreign trade agreements, with special regard, I suppose, to enhancing the value of sustainable development. You have the floor, Sophie.
Thank you very much for the nice introduction, and thank you very much for selecting my paper on the substantive environmental provisions in the chapters on trade and sustainable development in the EU FTAs. I would like to present to you today some background information on this paper and also some results. International trade cuts pretty much across all environmental problems, be it global warming, deforestation, biodiversity loss, and so on. Trade places ever-increasing demands on natural resources, but also increases the efficiency of the use of such resources. And precisely because of this interrelationship, if reconciling trade and environment is done in a good way, which means if conflicts are managed and synergies are exploited, trade can bring about greater prosperity and greater quality of life, and if it's not done well, trade can have a destructive effect on the environment. For a long time, the international trade regime had hardly any access points for environmental considerations. At the creation of the GATT in 1947, environmental issues were still seen as more of a domestic matter, and there was no such thing as an international environmental movement. However, members were already aware of the potential of environmental measures being able to restricting trade and attempted to address that by introducing GATT Article 20. In 1972, the UN held its first big conference on environment in Stockholm and asked the Secretariat of the GATT to prepare a study to contribute to this conference. And the Secretariat decided to prepare a study on the implications on environmental protection policies on international trade, which reflected the concern of trade officials at the time that such policies could be used as obstacles to trade and constitute a new form of protectionism. So I find it interesting that the first real interactions between trade and environment, or within these interactions, the primary concern was not how to integrate environmental aspects into the trade regime, but for environmental protection not to interfere with trade liberalization. Since then, within the multilateral regime, there have only been small developments on the relationship between trade and environment. For example, an evolving and less strict interpretation of the appellate body of Article 20G, the creation of a Committee on Trade and Environment, and environmental aspects being on the Doha negotiation agenda. However, more development has taken place within free trade agreements. There is a rising number of bilateral and regional trade agreements that contain ever more environmental content. And free trade agreements enable groups of countries to increase environmental cooperation and to negotiate on environmental commitments that go beyond what has been achieved in the WTO. The EU started to integrate environmental aspects into its free trade agreements in a variety of ways, in terms of legal force and priorities. However, following its 2006 Global Europe External Relations Strategy, it sort of streamlined these efforts, in general efforts to integrate sustainable development aspects by including a separate chapter on trade and sustainable development in its free trade agreements, which are devoted to labor aspects and environmental aspects. And the first time this has been done was in the EU South Korea FTA. And the chapter on trade and sustainable development in this FTA served as a sort of model and prototype for subsequent negotiations. As we already discussed yesterday, to integrate environmental aspects into free trade agreements is not some sort of discretionary foreign policy of the EU. The EU is constitutionally mandated to do so by way of Article 205 of the TFEU and 21 TEU. The structure of trade and sustainable development chapters in EU FTAs is very similar, close to identical in the different EU FTAs post-EU South Korea. There are preambular statements, the usual contextual statements, declarative provisions. There are provisions setting out a sort of institutional structure. For example, the parties to the agreements have to set up national contact points. There is the creation of a committee on trade and sustainable development. And interestingly, the chapters have their own dispute settlement mechanism because these chapters are not subject to the usual state-to-state dispute settlement as other chapters of the agreements are. There are substantive labor provisions, and there are substantive environmental provisions, and precisely those are in the scope of my paper's assessment. With my paper, I wanted to focus on the content of the substantive environmental provisions in the EU's STD chapters and on the type of commitments that are set out in the considered provisions. For that, I chose 3 very recent FTAs that I looked at, which is the EU-Vietnam Free Trade Agreement, the EU-Canada Comprehensive Economic Trade Agreement, and the EU-Japan Economic Partnership Agreement. Basically, I was interested in conducting this analysis because so many ambitious statements have been made about these chapters. For example, as I referred to in the title of my paper, the delegation of the EU to Vietnam said that the TSD chapter of the Vietnam FTA is robust, comprehensive, and binding. About CETA, the European Commission said that it has some of the strongest commitments ever included in a trade deal to promote environmental protection and sustainable development, and these obligations are binding with the same legal value as any other provision. In the context of TTIP, the Commission said that TSD chapters serve to safeguard basic rules that protect the environment. So with the analysis of my paper, I wanted to basically shed light on what sort of obligation the TSD chapters actually contain in the area of environment and to what extent these obligations are binding and enforceable. To do that, I use the formatting went a bit. I used this spectrum of commitments, which was conceptualized by the UN Environment Programme and the International Institute for Sustainable Development, for trade negotiators, but also to assess the environmental performance of trade agreements. There are different types of commitments that range from binding from non-binding to binding. The first one is a reaffirmation of existing commitments, which means the provision just reiterates a commitment that the party has already entered into. Such a clause is not binding and merely serves as some sort of political declaration. Then there are best endeavor clauses, which are commitments to promote, support, encourage, make efforts to endeavor to achieve a more or less specific outcome. And due to its auditory language, such clauses are also not binding. Then commitments to cooperate and exchange information on an issue. These provisions are binding in theory, however, their binding force in practice is not very relevant because it is unlikely that a party enforces another party's obligation to cooperate. Then the commitment to formulate unspecific policies and take unspecific measures in support of some agreed objective. Again, this is a theoretically binding commitment, but in practice it is difficult to claim a breach of this sort of provision because it is typically very ambiguously worded. And lastly, a commitment to specific actions and policies, which is a binding and enforceable clause. in my paper, I'm trying to look at every substantive provision that is included in the area of environment in these chapters. But for the purposes of the presentation, I chose 3 or 4, depending on timing, that I thought would be most interesting and that indeed are most frequently mentioned in the context of these chapters. And I would like to start with provisions on multilateral environmental agreements. So there are several ways in which a free trade agreement might relate to multilateral environmental agreements, MEAs. For example, one could clarify the legal relationship between MEAs and the agreement in the event of possible conflict. This may take the form of spelling out specifically the relationship between the agreement and certain MEAs. One could also create a baseline for environmental standards by compiling a list of MEAs that the parties have to commit to, and this is independent of what the parties have already signed up to. However, as you can see here, in all 3 considered FTAs, the EU opted for a very soft approach by merely reaffirming its commitment to implement in its laws and practices MEAs to which it's already a party. Another part of this sort of provision is the commitment to cooperate and exchange information. Again, this sort of provision is very similar in all 3 considered FTAs. In the case of CETA, the commitment to cooperate relates to trade-related environmental issues of mutual interest, the ratification or amendment of MEAs. And thirdly, provisions on multilateral environmental agreements contain an exception clause, a la Article 20 GATT. This is done a bit differently in all 3 agreements, as you can, well, in the case of, it's differently done for CETA, the same for Japan and Vietnam, but the effect is the same. It's a reaffirmation of a right that the parties already have under Article 20 GATT. So in the spectrum of commitments, provisions on multilateral environmental agreements in the FTAs I looked at are reaffirmation of existing commitments and commitments to cooperate or exchange information. The next clause I would like to present to you is the obligation regarding domestic environmental laws. These clauses have 2 different elements in the 3 FTAs. The first one is the prohibition of the parties to waive or derogate from, or to offer to waive or derogate from its environmental laws. This sort of core obligation is the same for all 3 agreements. However, in one condition they are different. For Vietnam and Japan, the derogating from or waiving has to be done in a manner affecting trade and investment, whereas for CETA, it has to be done to encourage trade or investment. So the implication of this difference in wording is basically that for CETA, one needs to prove an intent, whereas for Vietnam and Japan, one needs to prove an effect. And typically, it is easier to prove an effect than to prove an intent. Then the second element of a clause like this is the prohibition of the party to fail to effectively enforce its environmental law through a sustained or recurring course of action or inaction. Again, we have a difference in the condition as an encouragement for, to encourage, or in a manner affecting trade or investment between the parties. But what is more interesting about this element, I think, is the condition that it has to be done through a sustained or recurring course of action or inaction. Arguably, a violation will occur in very, very limited instances because of this condition through a sustained or recurring course of action or inaction. And interestingly, in the NAFTA environmental side agreement, in the equivalent clause of that agreement, parties are merely obliged to effectively enforce environmental laws. There's no such condition. In the spectrum of commitments, I've allocated this in the 4th category, so very much on the binding side of commitments. And this sort of clause has also been argued to be one of the most substantive clauses in these chapters. They basically address the race to the bottom issues, so countries lowering standards with the objective to attract foreign trade or investment. However, I think it's important to note that the considered clauses merely prohibit derogating from or waiving environmental laws if the intention to do so is to encourage trade or investment, or if doing so affects trade and investment between the parties. So waiving or derogating from environmental laws is only prohibited to the extent that it creates or is meant to create a competitive advantage. So my reading of this clause is that its rationale is primarily competitive considerations, and environmental considerations come as some sort of side effect. As an alternative clause that puts environmental protection at the forefront, one could imagine a clause that prohibits derogating from or waiving domestic environmental laws, if that means derogating from certain defined environmental standards, for example, in multilateral environmental agreements. The last clause that I would like to present to you today is the obligation to ensure a high level of environmental protection in the parties' domestic laws and policies. As you can see in this type of clause, which again is pretty much identical in all agreements, the wording is very particular. The parties shall seek to ensure and shall strive to continue. Because of this wording, even though the core objective of this clause is, from an environmental perspective, very positive, because of this particular wording, it is merely a best endeavor clause and has to be allocated on the non-binding end of the spectrum of commitments. So I was only able to present to you a few clauses, but in general, the provisional conclusion of my paper is that the number of provisions that really stipulate binding and enforceable commitments is very limited. And going back to what I said before, that the aim really should be to reconcile trade and environmental protection to get the most out of trade for everybody. This is not, in my opinion, not genuinely done, and these trade and sustainable development chapters are more of a greenwashing tool. Interestingly, the Commission is in the process of reforming these chapters, not just the environmental side, also the labor side. It has basically engaged in a dialogue with member states, other institutions, civil society organizations, and has concluded that the implementation of the TSD chapter should be stepped up and improved. That basically the idea is to effectively implement a global framework of environmental standards, and that more effective means are needed to achieve this. The Commission has already come up with a plan to do this and has compiled 15 concrete and practicable actions to do so, which includes working with international organizations, to have an assertive enforcement, to step up resources. But interestingly, there's no mentioning of the actual content of the substantive provisions. And that is basically how I would like to end this presentation, that, in my opinion, to do these things, the Commission should really look at strengthening the substantive environmental provisions in the chapters.
Thank you very much. But I think that the main part of your analysis justifies less pessimistic conclusions, at least as I see that. If I may borrow from Professor Courtier's language, we have seen that the European Union treaty-making policy in the field has enhanced a shift from environmental concerns being just a tool for a bar to international trade into an incorporation of environmental concerns in a regulatory dimension, giving formidable attention to the coordination between the international dimension of trade with domestic regulation of foreign relevant trade and services. Of course, you can improve and always do better, but it seems that a major step forward has been promoted and produced by the European Union policy in the field, as far as I see it, but I'm sure that the debate will be rich and there will be many comments from the audience. The next speaker is Paweł Frankowski from Jagiellonian University in Krakow. He is going to talk very much about the same things, but from a labor law rather than environmental law perspective. Paweł Frankowski, you have the floor. And here it is.
Yeah, that's okay. Thank you very much. Grazie mille. My name is Paweł Frankowski. I'm from Jagiellonian University. I know it's quite hard to pronounce. My project and my paper and my presentations on the compliance mechanism in EU FTAs, and I try to focus on labor stamp probable, but kind of compliance mechanism in TTIP, what we may have. The paper is supported, as you may see, by Polish National Science Center under that number. I will start from the research question, why labor standards and why this compliance is important. Still, we have a quite limited literature on the EU and labor standards. As you see on the screen, there are a few papers, a few chapters. Most of them, they focus on the comparison between EU and the US. Most of the scholars trying to convince readers that we have soft approach adopted by the EU, when the hard approach, or quite harsh approach, adopted by the United States. And we may expect and anticipate positive effects and ex post evaluation. In some of the papers, you can find a clause that, well, the phrase that academic analysis is unable to seriously engage in the labor standards, which is not true. Or there are significant limitations of the EU common formulation of labor standards, which is also not true at all. So I do have three research questions. First of all, why EU is so weak in promoting labor standards instead of quite strict lined in FTAs when comparing with tough American stand. Then I will try to find out whether, or starting from the point of view that since every political action is for someone and for some purpose, for whom are the labor standards? And in my opinion, labor standards in FTAs and PTAs, both in EU and US, are important for internal political processes, and to understand labor standards and to understand activity of EU and American counterparts, we have to focus on what is going on the domestic politics. And third and lastly, what kind of compliance mechanisms are possible for TTIP, and it's going to be in the conclusion. The time as a trigger is the year 2008, and my research started in fact in 2008 onwards. Three kinds of hypotheses. For the EU, the provisions of labor standards promoted by the European Commission, it stems from the logic of deeper and covert integration. So to have better market, to have better integration, we have to promote labor standards abroad just to convince member states it's important to have this right to regulate labor standards on the level of European Union. The second, we do have strategic installations of private and public actors. It leads to covert integration of cross-state powers, and in fact, labor provisions are smokescreen for economy. So in the way that private actors, mostly big companies and mostly automotive companies, are promoting low labor standards abroad just to keep a possibility for export. That's the case of Korea, that's the case of the United States, and we'll see probably what Mr. Trump will say next few weeks, that cars are going to be the most important issue for TTIP, but also for the revision of FTA with South Korea. And the third, the European Commission is seeking to maximize its institutional power over the member states and possibilities of regulation in this area, and that's why labor standards are included in FTAs, just to convince member states that it's good to regulate also on domestic level. So we have three weaknesses. First of all, the EU has presented itself as a normative power, what we may have heard yesterday, while in fact it's pursuing economic goals. There's a tendency to focus on the limited goals of possible EU goals and strategies, and in the result at the end we have quite limited text of agreement, or just like our previous speaker said, open-ended list of goals or targets. And the most important thing that we have, or we are witnessing the absence of the political competition between major EU institutional bodies and member states over the labor standards. Of course, there is a debate in the European Parliament over the labor standards, but in fact there's not no serious public debate at all. When we compare labor standards and the discussion of the delegated workers, it works, but when it comes to labor standards and free trade, it doesn't work. If you look on the American side, it's topsy-turvy, so it's a hot topic, and the question is why? Because it's a very useful tool to engage public opinion against free trade. How about research framework? I'll focus on transfer of cross-state power. I borrowed this idea for Richardson. For my model, I will focus on ideas of compliance, interests of compliance in the labor standards, and institutions of compliance. I follow the idea of Nicholas Yapko, the topos of the market, and through the market we can explain everything. This is a very nice buzzword, very nice slogan to explain and to convince other partners that we have to do this or that. At the end, we have our conflicts over the power and influence in FTA, and through compliance mechanisms, we can avoid this conflict or try to use this mechanism to keep the agreement. As I mentioned, the idea of the market or market ideas have been used to transform existing institutions. It's important both in the United States and European Union. However, these two actors are sitting in different camps. The ideas of regulations, harmonizations, trade, free trade, or market and free trade are just different. When you look on the policy of our labor standards, it is a deliberate action. It is not for normative reasons. So the actors are most interested in achieving certain goals and certain results, and this is why some of the standards are included into FTA, and this is why US position is so hard when it comes to Guatemala, for example, or Swaziland, when it comes to labor standards. At the end, if anyone would like to have a political monopoly over the conflict, the goal is to limit the scope of the conflict. How? Just to limit the number of actors involved into the conflict. On the American side, that's the idea of limiting the role of trade unions. On the European side, it's just to limit the role of member states. Last but not least, FTAs are a source of legitimacy. That's why current European Commission is pushing so hard to get more and more FTAs just to convince European citizens that the European Union is good for the trade. When one is good for the trade, it's good for the jobs. When it's good for jobs, it's good for the economy, and so on and so forth. And this is why TTIP gonna be important in American discourse. How about other conflicts? There are conflicts of the gates of the regulation, So how to define the market, a strong, effective, common, whatsoever. And the question is, what kind of political animal is the Commission in that conflict? On whose game do we play in regarding labor standards? And what kind of political animals we can expect in the United States? On the European side, it's quite easy. So we have commissions that are technocratic, competence-seeking, and policy-seeking. On the American side, it's more complicated. Mostly due to the fact that we are switching, so that American Congress is switched side in December last year when it comes to micro trade unions. Plus, we're expecting midterm elections in November this year, which may change the game when it comes to trade. I'll get back to this later. All of the sectors will find a possibility of conflict over the compliance and how to define the compliance and what we can do with the compliance. And even compliance seems to be less political or non-political. In fact, it is. Why? Because labor standards are supported by representatives of civil society, are supported by interest groups in the parliament, they are supported by the NGOs. However, they are not perceived as a threat for some reasons which hard to explain at the moment. European Commission uses the labor standards to limit the conflict over the FTAs, just to convince the European Parliament that we have to trade with other partners, and that's why we have labor standards and other chapters on environment and IPRs as well, in the way that free trade or trade with other parties, other countries is just a good thing, and then we can promote some norms. For US, Americans, they use labor standards to limit the conflicts over their FTAs and to support compliance mechanisms, but in different way. They use compliance mechanisms to promote a comparative advantage of American economy. In the way, if you want to export to the United States, you have to comply to some rules, and we do a lot to force the other party or to force the states to change the idea of labor standards. And that was the case of Swaziland back in 2013, I guess. Triggers on the European side. There are three kind of triggers. Well, I found three kind of triggers. First of all, they are market-driven, and what we see is expected automatization, autonomous transportation, and aging population that are important market triggers for more FTAs and more issues in the FTAs. When it comes to geopolitics, when you compare FTAs with South Korea, with Vietnam, with Singapore, New Zealand, Australia, the idea is to be first in the region and to promote good standards, good for the European producers. And then they are politically driven to expand the power of European Commission, and this is just a hidden agenda of every FTA. For EU side, for US side, market is of course about the export. However, we have to remember that US export is not that important that we may see in the media. Most of the GDP is from the domestic economy and domestic consumption. Plus, that's the Canada, the natural partner for US. And another is the cheap energy, which is important for the production. That's why the previous administration, the current administration, just switched sides from getting more and more from China to produce more in the United States. When it comes to geopolitics, is just to keep the leading role globally and in the region, especially in the Pacific. When it comes to politics, it's about expanding power over the states and the trade unions, and it's about the federal clause, which was in NAFTA, but also could be important for TTIP. But, and this is quite of latest idea, just to reclaim authority over the trade in the Congress. At the moment, even we have a constitution, the commerce, the right to regulate the commerce, which is in the hands of the Congress. However, there were two changes in American law in the 1930s and 1970s, and then the power over the trade belongs right now to the president, who is, well, less trade-oriented than we may expect. What kind of compliance mechanisms are important for FTAs? First of all, when we don't have any constraints, the governments will cheat. And this is borrowed from von Stein in 2016, and this is the statistically proof that when we don't have any constraints, the government will cheat. Why? Why not? In fact, limits of border for non-compliance are quite fuzzy, so it's hard to win a case in the international court or other arbitration body over the compliance, because it's about the spectrum, it is not about dichotomy. It's not about the black and white, it's about something else. On the other hand, when we do have an agreement, and when we do have an agreement and we know that interests are complementary, that's why we have FTA, any compliance mechanism are just unnecessary. So the general problem lies with the non-compliance. So what parties should do and can do to make agreements less problematic? So if we just change the logic of compliance into the non-compliance mechanism, this is just much more easy. How about the lesson learned? At the moment, we may say that the weaker negotiating position of the other party, the more likely compliance mechanism will be included in FTA. This is a story of FTAs between US and Colombia and Guatemala, but also with African countries on the mechanism of AGOA. When it comes to EU, the unstable economic situation in the European Union translates into bargaining power of third countries. And that was a case of South Korea, that was a case of Singapore as well. Right now, it's less problematic, and the compliance mechanism will be more important for EU, but we'll see that in next FTAs. Last but not least, when we have more pitfalls with compliance mechanism in FTAs, the more likely is the European Commission will decide to incorporate other actors, just to give more rights to European Parliament or other stakeholders into the trade policy in the way that compliance mechanisms will be based on other actors. However, the findings, neither the EU or third states are willing to implement TSD chapters, and that's the reality. From the perspective of EU member states, it's an irrelevant issue. However, we do have REFIT program. We do have country-specific recommendation coming from IMF. We do have memorandum of understanding between European Commission, European Central Bank, and IMF. And in this memorandum, we can find labor clauses which are important for the economy. When it comes to private actors, labor must be less costly for the business. So the lower number of the regulation is, the less costly is for the European economy. Situation probably will change after Brexit, if it comes or not. Nobody knows at the moment, or probably someone knows. But UK was one of or British government was one of the most important critics of current labor standards on the European side. So the growing standards when it comes to labor are not necessarily a good thing. When it comes to the US, they really do care about TSD. As a whole, it's a strong push to implement it, especially in the weak countries. From the perspective of the American states, it's an important issue. Why? Especially for southern states, they want to produce more, want to export more. There's a competition for developing countries, and to promote labor standards is just to keep them, developing countries at bay. They cannot export more, and this is good for the American states, not for the American government. But also, it's a good thing to overcome monopolies and to keep prosperity in particular states. If you again look on the domestic matters, what is good for Tennessee or Alabama is good for senators and good for the domestic politics. There are three sets of casual mechanisms for compliance in FTAs. It's constrained to inform and to transform. These mechanisms are inherent into FTAs and even unwritten, and most of them are in fact unwritten, and provide a powerful tool for political power. It will be a powerful political tool to outcomes even behind the paragraph. So there is no need to put compliance mechanisms into the FTAs when we know how to use this mechanism in these three sets. When it's about in the rule of law, we it can gain strength as an independent, non-questionable, and apparently non-political norm on its own. So when we discuss compliance, everybody knows what does it mean. In fact, nobody knows because it's unwritten, but it has some meaning. We do have the brokers of compliance. That's the US Congress, that's American states, but also European Commission. When it comes to BATP, just mentioned yesterday, as a bipartisan agreement over the trade, the compliance to core standards was based on ILO core conventions from 1998, and that is important for the current and coming FTA in US. On the other hand, we have state regulations when some of the American states, they have so-called right to work, so there's no need to, actually it's forbidden to join a trade union and as a prerequisite to get a job in some American states. And some of the trade unions, they suggest to adopt European standards, and for them, they're going to be better situation with European standards than they have at the moment. However, we also do have institutional compliance, and that's the role of European work councils. Right now, the TNCs based in the US, there are 16% of European work councils are companies that are based in US, and these companies, American companies, on the second place after Germany. So in Germany we have 180 TNCs with European Work Council, which are supporting the decision-making process in the companies. The US companies on the second place, 168. How about other institutions? In US FTAs, labor standards are well-defined and compliance mechanisms are very clear, and that's the case of FTA with Australia. This obligatory labor. Sorry, with Korea, with obligatory labor affairs council. Whether or not it works, I would say it has a moderate effects. When it comes to European Union, we do have very volatile obligations, especially when it comes to Korea or FTA with Vietnam. The case or interest, the case study is automotive industry. When we see what is most important thing and what most hot topic for current administration, that's automotive industry and cars. If we compare American workers in BMW and Mercedes plants and European workers, that's 1/3 of average wage in the automotive industry. So the cars produced in US are just cheaper, which means that if you look on BMW, they sold 1 in every 4 cars from X series are produced in the United States. It's an important thing for politics, especially when we know that these European producers are based in South American states, in US, BMW in Spartanburg, Mercedes in Vance, and Volkswagen in Saratoga. And they offer cheap labor, they offer high tax exemptions, and governors are desperately looking for any investment. And that's why they will promote low labor standards in TTIP. When it comes to Volkswagen, they are fighting right now with United Auto Workers. They lost the case in 2016. However, as I mentioned before, in December 2017, National Labor Relations Board has reversed decision on micro-unions, so which means that Volkswagen has some good cards at hand. And it's going to be, or could be, a strong argument against TTIP, but we'll see in the future. To conclude, labor standards in FTAs are smokescreen for internal processes, and any compliance mechanisms which are in FTAs are the result of deliberate action. And starting from Korea to CETA in 2016, European Parliament, the Commission, other stakeholders, they see different role of labor in the overall vision of European economy. When it comes to TTIP, labor standards important in BATP, mostly for developing countries, would be less important for European Union. Even if you look on the FTA with Australia or FTA with Korea,
It's just irrelevant. So there's no blueprint for TTIP when it comes to compliance mechanisms, and we will see what will be the decision after the midterms in November this year. Thank you so much. That's it.
Thank you very much. That was quite an intense policy analysis with a couple of strong statements, which I'm sure will stir some debate shortly. The next speaker is Francesco Cazzini from University of Milan, where he's a PhD candidate, and he will tell us about food trade within the European Union negotiations on TTIP and geographical indications, an issue which has already been tackled yesterday by Professor Manderia. Francesco Cazzini, you have the floor.
Thank you. Thank you, Professor Tanzi, and thank you to all Bologna professors for this opportunity. During my presentation today, I will address two different specific issues related to food law. The first one can be considered as a more classic topic, which is geographical indication, with the long-standing battle between the old war, which is basically the European Union, and the new war, so like the US and the other common law countries. And while the other issue I will address is international regulatory cooperation, and so how the US and the EU can have a kind of dialogue on technical measures and SPS measures related to food matters. So why food is a relevant topic in this transatlantic dialogue? The importance of the issues of geographical indication in trade negotiation is because the European Union recognizes it is unlikely to be competitive in the production of basic agricultural commodities, but that its long culinary heritage has created a number of premium products which are valued by consumers in the marketplace. I want to give you just a few notices on GIs. As some distinguished authors mentioned, geographical indication stand at the intersection of three different areas of international law: trade, intellectual property, and also agricultural policies. GIs are products originating from possibly very small areas, but are destined for global consumption. GIs may be produced by small companies, often unknown of majorities of consumers, but their reputation, if not stronger, are in any case compatible to those of multinational food brands. Moreover, the political implication of GIs is broader than any other food products, with the lobbyist actors really involved in Brussels, and also given the role of GIs in the common agricultural policy. If we then look at the international frame, at the WTO legislative framework, the first international treaty that properly mentions and defines the term geographical indication is the WTO TRIPS agreement. However, this treaty, with a struggle to find a generally accepted definition among countries that do not share common views, instead of giving a broad and comprehensive framing, comes to that term a more specific meaning. The TRIPS agreement recognizes GIs as one of the 6 forms of IP rights, and they are defined in TRIPS Article 22, while trademarks are defined in Article 15. Also, if we look at the case law, the WTO dispute settlement mechanism confirmed that these different IP forms are both distinct and equal, when it found that TRIPS Article 16 in relation to trademarks did not trump the provision on GIs, even though the terms of Article 16 seems to give trademark owners rights to prevent the use of identical or similar signs of marks. If we then look at the relationship between the EU and US, there is an historical disagreement on this matter. The common law approach of countries such as US, Australia, and Canada is more comfortable with the trademark regime as a way of protecting GIs, mainly using collective and certification marks. On the other hand, the European Union adopted a sui generis scheme. This is because the European countries perceive GIs as a more public asset that cannot be bought, transferred, or controlled by a single individual, as GIs are different, and thus it is necessary to have this standalone system for their protection. The US opposition started a long time ago in the wine sector, with the US trying to block the EU attempt to capture not only names like Bordeaux, but also other names like Chateau and so on. However, this fight has been, for the most part, resolved in the EC-US wine agreement. And in addition, the US has developed a system of wine designated areas, which are not very different from our GI system. Then the US opposition migrated to the cheese sector with the creation of the Consortium for Common Names, defining the Wisconsin cheese industry. Much of the opposition in the US to the EU's perceived demands for GI protection in the TTIP negotiation has centered on the alleged threat to common or generic names. Some US interests claim that some EU GI terms are used so widely that consumers view them as representing a category of all of the goods and services of the same type. Affected US industries have thus responded to the EU by establishing the Consortium for the Common Food Names, which is a Washington, D.C. based international initiative that aims to preserve the rights to use common food names. This consortium has garnered significant support from the US legislature on this issue, and particularly around dairy products name. This group is incredibly aggressive, and over 50 senators and 177 members of the House of the Representatives have signed letters urging the US negotiation to reject the EU attempts to appropriate common food names as GIs. If we then look at the European perspective, there is also the question of what the EU is prepared to pay in terms of concessions to persuade the US side to accept some of the GI demands. Previous agreements on GIs with third countries, including agreements on wines and spirits, were successful because the European Union offered additional market access for third country products in return to the protection of geographical indication. But given that much opposition to the EU GI demands has come from the US dairy industry, and is there a package of market opening measure which might persuade the US dairy industry to back an agreement? Such trade-off may be equally difficult for the EU to accept, and this is because the gains for greater protection for GI names in the US will accrue primarily to producers in particular member states, notably Italy, Greece, and Spain, while the cost of a market opening will be felt more broadly, including also producers in the Northern European member states. I then decided to have a look at GIs in different free trade agreements which have been adopted by both the EU and the US. And then I particularly looked at the Asia-Pacific region. And the first approach adopted by the EU to negotiate GI protection was based on specific standalone agreements, such as the 10+10 project with China, and also some sort of bilateral old agreement on wines and spirits. While more recently, the European Union has preferred to deal with the protection of GIs, inserting an IPR chapter in broad trade agreements as FTAs. However, the negotiation context regarding GIs in an FTA may vary from one third country to another, depending on its historical tradition and sympathy for GIs, agricultural tradition, and trade market tradition. So if we look at the current situation, what is happening today is placing another obstacle to the EU trade policy, is that these no-GI countries, such as the US, are negotiating with the same countries with which the EU is negotiating, its obligation on GIs, which are often in conflict with what has been agreements in the EU trade agreements. Thus, third countries' negotiations are agreeing with both the US and the EU and may find themselves with conflicting commitments. The EU also is thus attempting to export its particular model of GI protection in its preferential trade agreements, and in his encouraging other countries to adopt a minimalist trademark-oriented model of legal regulation of GIs, which is distinct from the sui generis EU scheme. Generally speaking, it is evident how divergent the approaches of the US and the EU are in the bilateral context. The main debated issues concern the additional protection extended to goods other than wines and spirits, as against the minimalist approach, the principle of priority as against the principle of the coexistence in the relationship between GIs and trademarks, and, as already mentioned, the problem of generic terms. At the bilateral level, both the EU and US have been able to achieve some modest success in advancing their approach regarding the protection or not of geographical indication. Yet, at the end of the day, the first come, first served rule remains the one governing the outcome of each negotiation. Some conclusion can be made on this aspect. The actual competition between the EU and US to impose their concepts of GIs across the world by means of bilateral and plurilateral preferential trade agreements with the same third country has two consequences. First, it is threatening the legal coherence of the national laws of the trading partners. And second, it is clearly undermining the possibility to create a uniform system for the protection of all GI throughout the world. In the absence of a common strategy, these bilateral agreements may jeopardize the coherence of a country's domestic system with respect to basic principles of the law. And the fact that GIs are regulated and protected differently in each country may prevent equal market access, undermining some of the main objectives of the TRIPS itself, like to set up a uniform and fair international intellectual property law for all member states in order to reduce the distortion and impediments to international trade. So, rather than looking themselves in a mercantilistic battle over a limited number of specific GIs by means of overlapping and conflicting bilateral agreements with the same Asian partners, but also with other countries with which these two actors are negotiating the FTAs, the EU and US should take a step back from Asia and focus on achieving a coherent compromise that could provide the basis for a multilateral agreement. So, looking at the final and more general observation, the small victories that the EU has achieved in answering some form of protection for some of Europe's most famous GIs in some of these agreements is not necessarily a reason to celebrate. The object of any international negotiation should rather to be set out of a series of basic and common agreed principles to address the essentially attributable test which is required by TRIPS Article 22. And the need for coexistence between GIs in trademark law and the problems surrounding a limited number of specific names considered both generic and both specific by consumer in different markets. The fact of having in place different GI systems and the attempt to impose this conflicting system on third countries through FTAs is undermining the main principle of the WTO, in particular the most favored nation and the non-discrimination principle. Thus, the EU TTIP should be seen as an opportunity to redefine how GIs should be protected around the world and not a means to continue this battle of ideas or economic interests. While looking then at the regulatory cooperation, it is a recent phenomenon that has been acquiring more attention in several FTAs. Regulatory variation among countries' legal system and disputes over whether these differences in national regulation are justified or not raise challenges and questions that have been recently addressed by IRC. The result of this collaboration is often to move to international standards, but regulatory cooperation can also involve agreement that can be based on equivalence or mutual recognition. And the trend toward IRC among states has become a significant aspect of international trade law in recent years, and there are a series of important initiatives in a series of FTAs. Which are the main challenges and opportunities for regulatory cooperation? TTIP, as well as other initiatives, respond to different powerful drivers. The first driver is mutual economic benefits, of course. The second driver can be conceived as a more strategic, so also political objective. And the third, which I consider the most relevant, is that if the TTIP succeed in promoting a high degree of EU and US regulatory convergence, its regulatory measures and approach could, through a variety of mechanisms, become a de facto global standards. I look at this phenomenon with a particular perspective that was also raised with a question which was also raised yesterday. And this is the possible conflicts of regulatory cooperation in preferential trade agreements with other WTO principles. The point is that the extent to which a WTO plus approach, as contemplated in a TTIP or in other FTAs, is consistent with the WTO approach based on non-discrimination among all members of the WTO is much more or less clear from the law and also case law than it's for preferential tariff or elimination of tariffs on a bilateral or regional basis, as it is mentioned in GATT Article 24. Both TBT and SPS agreement focuses on such standards in the food and agriculture sector. But neither of these agreements contain any equivalent of the GATT Article 24 provisions that will exempt regulatory cooperation in the context of a free agreement from the relevant WTO principle. Moreover, both of these agreements contain obligation to use international standards. And the question is how this obligation might limit the use of specific standards as a basis for free trade in goods among parties that are not part of these agreements. So this raises the issue of the extent to which such standards can exclude or impose greater barriers to products from WTO members not part of a free trade area. The WTO multilateral legal framework is permissive of regulatory cooperation and harmonization in the context of bilateral regional trade agreements, but at the same time there is a very limited ambit under the framework to operate a two-tier approach in which regulatory cooperation barriers to trade market access are higher for those WTO members that are just outside this agreement. So any such differences would generally need to be justified and based upon objective policy consideration, as opposed to the mere membership of the preferred states in these free trade arrangements. Moreover, the WTO case law stress international standards as a basis for regulatory cooperation or harmonization or both, as well as the importance of the openness, transparency, and participatory rights of all WTO members in international standardization activity. It is not permissible to allow a WTO member without justification to offer regulatory cooperation to some states, such as member of a bilateral or regional free trade area, but to deny at the same time the regulatory cooperation to similarly situated states. So the new regional agreements being negotiated now may provide avenues for enhanced regulatory cooperation, but this should be consistent with WTO norms, and these avenues must be opened up to all WTO members where the conditions are appropriate for their participation. In practice, the efforts toward regulatory cooperation are constrained by several factors that may vary across countries, and these constraints include some interest group that IRC will mean harmonizing down, and the concern of others interest group that IRC will mean harmonizing up. Moreover, there could be also restriction on sharing information across countries or agency, and also limited agency staff and resources, and pre-existing constitutional and statutory requirements for making regulatory changes. And all of these issues, all of these problems, I think that are more evident with regard to equivalence, and in particular with the concept of equivalence as contained in the SPS Article 4, because in this case there are problems that also have been addressed by the SPS and the TBT committee as regarding as guidelines as to implement equivalence in bilateral agreements. But while harmonization and standardization on international matters could be more easily, I believe that in this case an arrangement should be quite hard. And as a concluding remark on regulatory cooperation, I thought IRC has so far put a priority on reducing regulatory variation and thus to reduce trade barriers. Learning from regulatory variation should also be an important feature of this phenomenon. Studying regulatory variation can help match regulatory policies to local preferences and circumstances, and can help evaluate alternative policy options, and can help guide convergence to select optimal policy approaches rather than converging hastily on arbitrary or suboptimal approaches. And thus, and in particular in the TTIP framework, regulatory cooperation should thus include cooperation not only on reducing trade barriers through convergence, but also on learning from the variation about the policy impacts and about the optimal policy design. Thank you.
Thank you.
Thank you for complementing a rich discussion already yesterday on this sectoral challenge. The next speaker is Luisa Marin, who is assistant professor at University of Twente and a visiting scholar at Bocconi University. Luisa Marin will tell us about balancing between privacy with regard to data protection and free flow of data in preferential trade agreements. Dr. Marin, you've got the floor.
Thank you very much, Mr. Chairman. Thanks to the organizers also for giving me the opportunity to come back to the university where I graduated many years after. And I'm going to talk about a topic that I've been exploring since a couple of years, since before the Schrems judgment of the Court of Justice, that has been very important and very relevant in this field. And therefore, I'm going to talk about my presentation is titled Personal Data Are Not Bananas, and I'm going to talk about how data protection laws in Europe affect TTIP, preferential trade agreements, and in general, trade with third countries. While preparing for this presentation, I've been checking where we stand with the TTIP. And if we all know that Privacy First of Trump has put negotiations on TTIP on hold recently, there is a declaration of US Commerce Secretary Wilbur Ross stating that while US has terminated the Trans-Pacific deals, he didn't mean to terminate the TTIP. So while it is difficult to predict whatever happens around Trump and his head, I think that the fate of TTIP is not dead yet, so we might have in the future some revamp of discussions around TTIP. After this premise, I would like to start from sketching some basic information, since I assume you're not TTIP scholars per se. And I would like to put on the table some basic information on how these issues are sensitive and how these issues are relevant. So data protection in Europe is very much a concern, is a fundamental right, is after the Lisbon Treaty a core policy of the EU with Article 16 of the TFEU. And recently also the Court of Justice has contributed to the constitutionalization of data privacy rights with judgments like Google Spain and Digital Rights Ireland. Digital Rights Ireland, that caducated the Data Retention Directive, has had important implications also at the external level with the Schrems judgment that I assume we all know, but it has been caducating the safe harbor scheme for data transfer between EU and US. The constitutionalization of data privacy rights at EU level is going further because also recently the Court of Justice, with opinion on EU-Canada PNR agreement, has had the chance to further develop and take ahead the process it had started in 2014 with the so-called privacy spring of the Court of Justice. On the other side, we all know as well that the transatlantic divide between the US and EU on privacy is huge. So even if both EU and US protect privacy, the differences in the conceptual terms and the practice and the enforcement are really significant. I have to be brief on this, but I have to say that in the US, privacy is protected as a threat against property. The enforcement mechanism is based on civil law mechanism. There is no general approach on regulating data processing. That is the case in Europe with the data protection regulation. And in the US, therefore, privacy is protected as a threat to property, as an expression of liberty, whereas in Europe, data privacy rights embed an idea of human dignity. In the US, so we have therefore a sectoral approach, whereas in Europe we have a general approach to data protection, okay, with the Data Protection Directive. I could be more long on this, but I think that, this is enough to tell us that we have significant legal divergences in terms of scope, in terms of how we protect data privacy rights, and toward whom we protect privacy rights between the EU and US. At the same time, international trade is not really concerned with privacy. In the GATT, we have a general exemption as to privacy rights from the GATT sphere, and also the website of the WTO in a clarification, says that WTO has had nothing whatever to do with internet privacy. So apparently these two different words and separated words are nevertheless very communicating, and that's why also these issues are very relevant and also not that easy to tackle in the practice. In spite of being legally in different words, they in the practice very much influence each other's. So I would like to start from these two quotes of "Personal data are not bananas" by Spiro Simitis, and also by Viviane Reding, former Vice President of the Commission, who stated, "Personal data is not a red tape or a tariff. It is a fundamental right, and as such, it is not negotiable." I think these two quotes, the position of Reding has been upheld also by Juncker, stating as well that fundamental rights are not negotiable in his State of the Union speech of 2016. These issues help us understanding the specificity of data protection issues in relations with preferential trade agreement. On the one side, we have data privacy rights as fundamental rights, but then at the same side, from the perspective of international trade, we have data privacy laws that can act as an obstacle to trade. Recently, we hear talking about digital protectionism, data imperialism, but trade needs, to some extent, free flow of data in order to prosper, in order to be there. On the other side, another aspect we have to take into account is, well, if Spiro Simitis said that personal data are not bananas, personal data are nevertheless a very special commodity. They do have an interest as goods, and they are of interest of both private authorities but also of public authorities. Okay. So data are not bananas, but even much more valuable, much more relevant for political power, and we all know about the Snowden revelations, the Facebook Cambridge Analytica scandal. We know that Russia is always interested in having data, and how can they influence, international politics on that. So I think that the world has gone beyond what Spiro Simitis said. Personal data are not bananas, but they are also, in a way, much more relevant, and therefore we have to regulate what happens with data. Okay? If not, the market will take the lead, and not only the market, and I think at Russia. So against this background, I think that I've explained this already. Then the question and the interest of this conference for me was indeed how to match rights, values, and trade. Is it still possible to square the circle around data protection, privacy, and trade? Is it a circle or a Bermuda Triangle? And we'll see why it can be a Bermuda Triangle to some extent. My question is, therefore, shall we have inclusion or exclusion in data protection rules in the TTIP? And if we opt for exclusion, what then? And then here I will have the chance to talk about data protection directive, to mention some concern with the GDPR, and to mention also the state of the relations between US and EU with the privacy shield. And I will conclude with problematic questions on privacy power Europe, on this Brussels effect, on the extraterritorial effects of data protection laws. So on this I could be very brief, because we will have a TTIP with or without data protection clauses? Well, it will be without, because for legal and political and pragmatic reasons suggest that these two words should remain separated. Content-wise, preferential trade agreements have been dealing with issues different from fundamental rights, therefore it's better they are separated. Also from a practical perspective, the debate around TTIP and as well the debate around privacy shields, they are very much polarized. They are politically very sensitive, legally very complex, so rather keep them separated and keep them separated in order to not to undermine, not to jeopardize the success possibility of the negotiations of these two legal instruments. The TTIP is already quite sensitive of itself, so rather keep data protection issues out. But then we have the question, and here we also have the recommendation of the European Parliament toward the Commission, and this is really the official position within the EU. No way, no possibilities it will change. Therefore, the issue is if data protection issues won't be in the TTIP, then they will be dealt with the ordinary regime. And the ordinary regime means data protection directive for a few days, because 25th of May, in a month and a half, the GDPR, so General Data Protection Regulation, will enter into force, and that's a new word. And means also privacy shields. Privacy shields is the replacement of the safe harbor scheme. Well, when we talk about these issues, we have to recall ourselves as life has changed after Schrems. And with the privacy shield, I can be brief on it, but we have to say that the dreams of Schrems have met the reality of EU-US relations, also in the context of privacy. So if we have to say that the privacy shields is an improvement to the previous situation of the data of the safe harbor decision, the recent evaluations of the privacy shields nevertheless show several criticalities that the Commission is more diplomatic in tackling. So the report of the Commission is showing some diplomatic enthusiasm, so to say, with underlying in a diplomatic way many criticalities that are still on the plate. And another actor, very important at EU level, the Article 29 working group. These are the gathering of the national data protection authorities. They are playing so to say, the role of the bad guy, in the sense that in their report toward the US, in the report they said there are many aspects to improve, the US should tackle them seriously, otherwise we will threaten to activate national courts, and national courts might then make a reference to the Court of Justice for a new, so to say, Schrems legal saga. To conclude on this, I want to say that the privacy shield is important, is a step ahead. There are many problems still with the adequacy framework, because many of the engagement that the Obama administration has taken in the negotiation of the privacy shields has been put on the fridge, on the freezer, on hold by Trump administration. Therefore, for me, the point that I want to give you is that the privacy shield is the current framework for transfer of data toward third countries, toward the US, but it's also very much important to keep a dialogue open, to discuss problematic issues, and to negotiate continuously with the US in order to have an enhancement of standards from their side, and in order to prevent that fundamental rights and data protection rights can end up being jeopardized, as we have seen also with Snowden revelations. There is still much to work on in this context, so it's still important to play a kind of carrot-stick game with the US and to negotiate around the privacy shield. Okay? On another dimension, I have to mention some aspects that are, I think, relevant for not only for the relations with the US, but also for more generally relations with other third countries, is that, with the GDPR, there are also several provisions having extraterritorial effects, and the most sensitive is Article 3. Here, it's clear that the role of the EU in the context of data protection is to set the standard, the golden standard, as Viviane Reding says, and there is very much a rhetoric of the EU having to set the standard for the rest of the world in this sphere. Scholars talk about privacy, Brussels effect. Political scientists talk about privacy power Europe. There are critical aspects of it, and we have to think about it. And I think that in this respect, also lots of empirical research is needed in terms of checking the consequences in third countries of the data protection framework of the EU. Critical third countries, economically weaker third countries talk about digital protectionism, digital imperialism. So I think that we have to think about it and to study the implications of data protection laws beyond the borders. And by stressing the critical, so to say, provisions of the General Data Protection Regulation, I just can make an example to give you an idea, and I will not bother you with the technical details of data protection law. But according to the new regulation that will enter into force, if you book a trip to California from a US local agent, and this website has advertisements in English, French, and Spanish, and you can pay in euros in their website, well, the GDPR should apply. And we think, okay, in this case, you could make the same example for a travel agent around the world, whichever countries you consider. So imagine a travel agent from an African country is in principle, in such a situation, the GDPR should apply. And as you can see, there is here a weak territorial link with Europe. Okay? The service might be in the third countries, the payment might be in the third countries, the internet is the medium. Okay? So I want to stress this case to, of course here I'm broadening up the issue beyond the TTIP and beyond EU-US relations, but I think that there is a point, and scholarship has in this respect stressed that EU should rethink its rules to regulate data flows with third countries, thinking also at concepts like enforceability. I mean, it's okay to have extraterritorial effects for EU rules when there are also enforceability chances of these rules. And also we have also to think that this concept of appropriate level of protection is also very relative. I find it very much problematic to think of the European Union that it can apply the golden standards to the whole world. There are here, in my view, huge legitimacy questions. And so when I think at these issues, I think that we should take inspirations from private international law and think at conflict rules of international private law and to link situations to jurisdictions and to enforcement mechanisms. Another idea advocated is global privacy regimes, a EU treaty on this, wonderful, but be very careful with this wish, because then you might get a very diluted thing, very diluted instruments, so to say. So the warning I raise is that, yes, we have this Brussels effect, and I think it's wonderful that the EU takes this strong stance toward actors like Google, Facebook, these global actors that are really powerfully, economically powerful, and they can therefore influence the world. But I think that there are also huge economic costs for economically weaker third countries, and I think that this is a problem. And then my question and my reference to the Bermuda Triangle is not only funny, because then the problem is that Article 3, Section 5 of the TEU is stating that the EU, in the relation with the wider world, shall promote its values. And this is also free trade, eradication of poverty, and protection of human rights. Therefore, I suggest that the way forward is to take rights seriously, of course, also in data transfer agreement, and I think that here there will never be enough attention in the relation with the US and in the relation with these tech giants that are economically very powerful. But I think that there should be no formalism and no unilateralism in imposing standards, but rather flexibility and search for ad hoc solutions in a context marked by legal pluralism and differentiation. So a kind of differentiated multilateralism is, in my view, the approach the EU should take in dealing with extraterritorial consequences of its data protection laws. Of course, in this context, the EU should hold to some core values, and among them, protection of fundamental rights, also as they are protected by the Charter and by the Court of Justice. Thank you.
Thank you very much for your lively presentation. It's probably the most difficult sectoral challenge, the one you just depicted, if only for the fact that it's already been set aside by the European Union from the TTIP negotiations, but you combine possibilities of regulation along the pattern of international conflict of laws on the one hand, maybe a United Nations multilateral negotiation. Now, I don't know how much it is my fault. We started a bit late. Maybe just a round of questions. The floor is open. I see Professor Laurent Mandelier. You have the floor here, please. Thank you, Lucia, for the instructions.
Thank you very much. My question is for Dr. Lucia Marin. Do you think that in an indirect way, the GDPR regulation represents a step of the European Union, or pushed by some countries of the European Union, to close the Internet loophole in trade? The Internet loophole, the kind of limbo in which the Internet is treated in the field of trade. So, in your brilliant presentation, you connected the fact that GDPR GDPR or privacy issues were left out of the WTO construction, or largely out of the WTO construction. Still, the privacy regulations are also a way to enter to a back door, or may be a way, to your opinion, or may not be a way to contribute to the effort of the EU to establish, of some EU states, to push for taxation on the on internet transactions and so on.
Thank you for that question. Perhaps before Dr. Marin, you answer, we can take other questions. Professor Gauthier, please.
Thank you very much for a very interesting session. I have questions for all the speakers very quickly. To Pia, do you think that older investment protection agreements with stabilization clauses could be challenged on the basis of subsequent trade and treaty practices, recognizing the right to regulate? Yeah. And to Sarah, I fully agree with your assessment that this is greenwashing. Where do you see the way forward, in particular in addressing PPMs and then bringing environmental concerns into negotiations on energy? And should energy be a chapter on TTIP? On labor standards, I was a bit surprised by your conclusions. I found it very interesting, but you didn't mention the NAFTA side agreement, which is the gold standard, which is not a hard law approach. So how do you reconcile this with your conclusions here? And on GIs, I would like you to investigate the TPP language, which is introduced by the US I think it was taken out, but which gives you the answer how the Americans reacted to the recognition of GIs in CETA. And this is very important because you need to take this into account for preparing your reconciliation with in TTIP. And another point is also that so far the rules on regulatory cooperation do not extend to the IP chapter. I don't know. This is an institutional divide. People don't talk to each other. But I think your idea of actually using regulatory convergence in IP is a good one. I don't have a question for you. Sorry.
Well, thank you very much. That was quite a substantive fire with intelligent weapons. And I will close the floor as to the question. So I may ask Dr. Marin first to answer the question from Professor Mandelier, and then we'll proceed in order. You've got the floor.
Yes, thank you for your question. Yes, I think that GDPR is to some extent an attempt to regulate the internet, and I think that also the Court of Justice has taken this road with the Google Spain judgment, and I think that to some extent the clauses of the GDPR that I've mentioned, Article 3 and Article 4, are a codification of the Google Spain judgment. So I think that there is indeed consolidation of this approach, in my view. At the same time, I think that this is indeed a role, a context where the EU has to do something, I would say. And I think that this is also important at the global level for being a strong actor on the international stage on the discussion around the negotiation of the internet, which is of crucial importance for the world. Okay, so this is really a crucial issue because I think that the regulation of the internet and an open, free internet, and being a strong actor in this context is a mission that the EU has to take seriously. However, as I've indicated, I think there are also problematic aspects of it. I think that there is also very important that there is some discussion and some rethinking about the, some discussion and some rethinking as I have indicated, but I'll be brief and I'll leave the floor to my colleague.
Thank you very much for your brevity. Pia, would stabilization clauses be abrogated, derogated from by subsequent agreements? I'm glad I don't have to answer that question.
Really, I don't have quite absolute answer. Stabilization clauses are usually included in contracts or were typical of contracts, so were typical of a private law perspective. This idea of the inclusion of right to regulate is a sort of, in my opinion, might be a sort of preventive tool. Because if you think of enforcement of these possible clauses on the right to regulate, in the end, from the perspective of a host state, would not be the most appropriate solution, because in the end, a state should go before an arbitral tribunal, defend itself, or at least counter-objecting to this claim for compensation. And so it would be a cost, because arbitration is quite expensive. So at least at the first stage of arbitration, still the host state would be in front of an arbitral tribunal. On the other hand, these clauses on the right to regulate would be appropriate if no arbitration proceedings would start, I believe, at least, the most appropriate solution. Okay, thank you.
Thank you. Perhaps that question could also apply to umbrella clauses, and then the answer should be probably found within the domain of retroactivity of treaties. But I'm not going to tell you how I think it would apply. Quick answers, please. I've been receiving distractions to that effect, please.
So the question was whether there should be a chapter on energy in the TTIP. And even though I'm not an expert in energy per se, I think it is not necessary to include a separate chapter on energy, just in the way that I think it's not necessary to include a separate chapter on environment, but to include energy aspects. For example, trade in green energy should be reconciled with trade objectives in general. There should be like a big overhaul to manage trade with other objectives, and I think to have a little chapter that addresses these things is just not good enough, not deep enough.
Thank you. Last answer to the last.
Okay, very quickly. Yeah, I'm surprised by myself as well. Well, when I'm interviewing people in Mexico and in US about current and future FTAs, none of them mentioned NAFTA in the first place. And I was asking, why? Oh yeah, that's NAFTA. But it's regional. It's obvious. That's why it was obvious for me. Yeah, you are right, that's a golden standard. That's true. It should be mentioned on that. However, it's under revision, plus we have Canada and US and NAFTA and Mexico, which has a different standards when it comes to labor, and it's still under the revision right now. Okay, great.
Thank you very much. The announcement is that the break will last only 10 minutes, so we shall reconvene for the next session at 11:30 sharp. Thank you very much for your attention, and thank the speakers. Thank you.
Does this work? Yes. And this one, test, test. Okay, can I invite you to take your places, gently come forward. I have no idea. They may come in later. Yeah, if they were there yesterday. I'm sure they were. Voilà. We take it in the order in which it comes. Okay. And you get about 20 minutes. And I hope stick to that like the others. Because... Okay. 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 Okay, good. So Marion, we take it in the order in which it comes, yes? We take it in the order in which they appear on the agenda. Yeah, in the order in which they appear. So you would be talking third. Yeah, before last. Okay, welcome to you all to this very last panel of a very rewarding conference, it seems. If you have difficulties understanding the acoustics, because the acoustics here are not very good, so I invite you to come forward because you might be profiting more from the insights of the different panelists. I would like to thank the organizers for having me here preside this panel. My name is Nanette Neuwaal from the University of Montreal. As I said, this is a very rewarding panel. Also, I noticed that there is a certain symmetry in the organization of the panels, in the sense that the first panel was a transversal panel mainly, and then we had two panels that were largely sectorial or sectional panels dealing with specific issues regulated in or to be regulated or not to be regulated in TTIP. And so we're ending now with, again, a transversal panel, and I hope that the panelists will also be able to refer to some of the statements made earlier today and yesterday on the sectoral issues, if they can and if they wish. So, as you will have noticed, we have a panel of 4 panelists. This is in order to leave some time for Professor Marosco of the University of Ghent to give his conclusions and comments on the conference as a whole. So you will be listening to 4 different panelists that will deal with transversal issues relating to the impact of deep trade agreements on the EU and its member states, and also come back to the issue of human rights and fundamental values. And this is important, of course, because human rights and fundamental values have received a renewed interest since the entry into force of the Lisbon Treaty. And it's clear that according to the Lisbon Treaty, human rights and fundamental values are to be upheld also in external relations. The Lisbon Treaty is important, so the last decade must have seen a shift in attitude of the European Union. I won't deal with the entire contents of the Lisbon Treaty, but for one thing, it marks the entry into force of the Charter on Human Rights and Fundamental Freedoms. But also, it reinforces explicitly the legal personality and the legal status and the impact of the European Union on international affairs, on external relations, as it gives the European Union a new explicit objective in the treaties, and even it is under the Treaty on European Union the first objective mentioned of the European Union. Apart from that, there are explicit new competences in the Lisbon treaties. Some of them have already been mentioned. Energy policy, also climate change, and the fight against poverty was mentioned, and among others. So internally, there are also new explicit powers and more qualified majority voting. I refer generally to justice and police cooperation, the fight against terrorism, so in the area of liberty, security and justice, the Lisbon Treaty has led to a greater activity also because the inclusion of the possibility of closer cooperation, and it is of course a fact that human rights and values impact also on those areas. In the commercial sphere, the Lisbon Treaty is important for, among others, the powers in regard to data protection, public services, to mention only a few. Since the Lisbon Treaty, the European Court of Justice has had an increased say, also because of references by different actors. As regards the external sphere, some of these agreements have been mentioned more or less at length. I mentioned the CADI jurisprudence claiming the primacy of EU human rights and fundamental values in relation to resolutions of the United Nations. I mentioned the second opinion on the accession to the European Court of Human Rights relating to the autonomy of the European Union legal order. One of the speakers mentioned the safe harbor decision, in which the court annulled the decision of the European Commission in relation to the United States, but also the PNR agreement of Canada. The annulment of the decision of the European Commission regarding the European Commission's initiative to stop TTIP and CETA, and the Achmea case is also of relevance, of course, in this field. These are all decisions of the European Court of Justice that have an importance for the application of EU fundamental values and human rights in the sphere of external relations. And last but not least, now before the Court of Justice is the request by the Republic of Belgium for an opinion concerning the question whether investor-state dispute settlement mechanism included in CETA is compatible with European Union treaties and the Charter of Human Rights, which will then which will probably decide and hopefully decide on questions of the autonomy of the legal order and hopefully also the principle of direct effect of bilateral agreements. So there's plenty of reason to expect that human rights and fundamental values will play an important role in the conclusion of agreements such as TTIP and other free trade agreements. And this will have an importance not only for the interpretation of constitutional principles in the European Union, but also for the shaping of the international order by the European Union. And to finish my introduction, perhaps one should also think about the fact that one of the fundamental values included in the treaties ever since 1985 is the principle of democracy. But as Brexit politics in the United Kingdom may show, the notion of democracy has more than one meaning. However this may be, the question is justified in this project concerning deep trade agreements, whether and to what extent such agreements impact on democratic values in the EU and its member states. So we've learned yesterday that the nature of trade relationships has changed over the years. Has the EU evolved enough so as to generate enough support for these agreements by the electorate? So I'll now, after these general introductory statements, I would like to give the floor to the four speakers we have around the table, and we take them in the order of the presentation on the program. The first speaker will be Maria Laura Marceddu of King's College, and she will deal with the issue of transparency as a tool for fundamental rights protection, the EU as a global standard setter. I understand that this paper was co-written with another researcher. So maybe you can say a little bit about who is responsible for what and how you came to this paper.
Okay, good morning everyone. First, I'd like to thank the organizer, especially Professor Lucia Serena Rossi and Federico Casolari, and of course the University of Bologna hosting this conference, and LAwTTIP Jean Monnet Network for putting this conference together. It is truly a great pleasure for me to be here with you today. Now, since I am supposed to talk about transparency, I think that the first thing I need to disclose is that this will be a co-authored paper on a project on transparency I have the pleasure of working on with Giorgia Sangiuolo. Giorgia is doing her PhD at King's. She's here, just sitting in the back. She's actually the EU law expert. I'm more the trade investment geek, so the both of us will be more than happy to answer to your question at the end of this round of presentations. Now, having said that, as the title of our presentation suggests, our idea is to discuss whether the EU is indeed becoming a standard setter with respect to the application of the principle of transparency, and why this might be important not only in light of a future EU US agreement, but more broadly in the context of future EU investment agreement and also in the context of the Brexit negotiations. Now, the structure of the paper, and I'll try to follow this outline as much as possible, but of course, due to time constraint, I won't be able to actually go into much detail for each of the points I am about to outline. The idea is to divide our presentation into three main areas. The first one, we thought that a good way to kick off the debate is actually to understand, to analyze this constitutional nature of the principle of transparency. So basically, what is the legal standing of this principle of transparency in the context of the EU external relations? The idea is to give you a flavor of the EU legal foundation actually underpinning the choice of transparency. This is, I'd say, more a theoretical part in which we actually explore where transparency is mentioned in the EU treaties and where reference is actually found of transparency in the context of the EU external relation. Complementary to this first theoretical part, the second section will revolve around, will be a more practical section and will revolve around how actually this principle of transparency has been implemented, has been translated into practical terms. Now, given the vastity of the EU external relations, we have decided to narrow down the focus of our attention basically on the EU international investment policy and in the context of the Brexit negotiations. The idea is to understand what have been the instruments that have been put forward by the European Union institution at treaty-making level and dispute settlement level, and also to draw some comparison with other regional blocs. I fear that I won't have time to discuss dispute settlement transparency or to draw comparison with other regional blocs, but I should be able to give you an idea of the novelties that the EU has introduced at treaty-making level and also in the context of the Brexit negotiation with respect of the application of the principle of transparency. And lastly, I'll try to draw some conclusion in order to assess whether the EU is indeed becoming a global standard setter and raising the bar as far as the application of the principle of transparency is concerned. Now, the constitutional nature of transparency in the EU external relations, so basically where we can find reference to transparency in the EU legal order. If we look at the European treaty text, the first thing to note is that there is no explicit reference of transparency under Article 2, which actually set out the tone of the value underpinning the European Union. We have, in fact, reference to human dignity, freedom, democracy, rule of law, pluralism, non-discrimination, tolerance, but there is no explicit mention of transparency as such, of transparency as a value per se. Transparency is, however, more explicitly spelled out under Article 11 and under Article 15. If we look at Article 11, for example, transparency, there is emphasis is put on the fact that the public, which comprise citizens, representative association, and civil society, needs to be kept informed, make known in the word of Article 11. And this public, which is quite heterogeneous, should not only be put in the position of being informed, but also it should be engaged in a public debate. And the condition under which this debate should take place is that the European institution carry out an open, transparent, and regular dialogue between civil society, the public, the people of Europe, and the European institution on the other side. Still in Article 11, in the last paragraph, there is an express duty down to the European Commission to carry out broad consultation with parties concerned. So there is an explicit duty down to the European Commission to conduct this dialogue in more practical terms and actually conduct consultation to understand which is the position of the European citizen in respect of different areas of the action of the European Union. Complementary to this, we have Article 15, which actually builds on what Article 11 has already outlined and still emphasize the need to keep the, to conduct the work across all the European bodies and institutions as openly as possible, and furthermore introduce the need, emphasize the right of access to document of the European institution. So, taken together, this idea of getting the public informed, of getting the public engaged, of getting the public consulted through broad consultation and also through an open and regular dialogue, as well as the right given to every European citizen, any natural or legal person to access the document produced across the European institution, are indeed bold signs that transparency is given a prominent role in the European legal order. So it is true that transparency is not explicitly mentioned under Article 2, but it is given a prominent role under Article 11, for example, and under Article 15. So it is not an exaggeration, and it comes with no surprise, the idea that transparency is actually a key component of the EU legal order, which is our main thesis in the paper, and it is a prerequisite, is something necessary to enhance the legitimacy of the European Union decision-making power, because it is thanks to transparency, in fact, that individuals are not only put in the position of being informed about what is actually happening in various areas of the European Union action, but is also put in the position of actually influencing the decision-making process underlying the European institution, and is also put in the position of scrutinize whether the decision makers are indeed accountable or not. And this responds quite effectively to the idea of a multi-level system of governance, which is at the foundation of the European Union. Now, bearing this institutional setup in mind, our idea is to understand whether this idea of transparency, whether this principle of transparency is actually being translated in more practical terms. As I said before, we would like to test, to apply this principle of transparency in the context of the EU-led investment policy and in the context of the Brexit negotiations. Now, before going further, just to be sure that everyone is more or less on the same page, I'd like to spend a few words on this new European investment policy. Basically, before the Treaty of Lisbon, competence over international investment agreement was exercised predominantly by the European member states. After Lisbon came into force, it is the European Union that took on exclusive competence in the investment field. Specifically, what I'm saying is legally grounded in Article 207 and 206, and according to which foreign direct investment is now in fact listed under the common commercial policy as an exclusive EU competence. So it is in the light of this competence given to the European Commission that the Commission has indeed started to negotiate its own investment agreement with third countries, and aiming to gradually replace the extra EU BIT bilateral investment treaties of its member state with new European investment agreement. Now, we don't have European BIT as we used to know the member state BIT, but now we have investment chapters that are part of broad, more comprehensive free trade agreement. So, for example, in the case of CETA, we have a very comprehensive free trade agreement of about 29 chapters, and Chapter 8 is actually devoted to investment. So we don't have just a BIT between Canada and the EU, but we have now an investment chapter that is part of a more comprehensive architecture. So now, how has this principle of transparency been applied at treaty-making level? I'd like to start by saying that the novelties introduced by the European Union has been dramatic, especially if we consider that for a very long time, international investment negotiations have been conducted by diplomatic or governmental representatives behind closed doors, without allowing any kind of public participation in any political debate, especially if we compare this kind of treaty-making approach, the EU treaty-making approach, with the treaty-making approach taken for a long time by the European member state, for example. So, among the most interesting novelties that the European institutions have put forward in negotiating their investment agreements, there are a few that I just put in this slide. First of all the text of the agreements, or in the absence of an agreement, all the European negotiating proposals are freely available online. At the moment, the only exception is the EU-Japan Economic Partnership Agreement, for which only certain chapters have been released online. In addition to this, the Commission have also released what they call some sort of explanatory fact sheet, and these are short documents. They are normally 5-6 pages long, by which the Commission seeks to provide clear and simple explanation of extremely complex issues. For example, there is a fact sheet about ISDS, Investor State Dispute Settlement, which explain also to those who are not specialists, who are not engaged in the investment debate, what the Investor State Dispute Settlement mechanism is. They are also, of course, written in quite neutral language, so they are not pro-investor or pro-state. They don't really take side. They're just simply explanatory documents that put also non-state, non-specialist actors in the position to understand, or at least to have an idea of what the document they are given access to are about. Now, probably the boldest novelty the Commission has introduced in its treaty making with respect of transparency is the conduct, the carrying out of public consultation, as are actually prescribed in Article 11. This, in my opinion, marks a radical turnabout in the way investment agreements have been negotiated for a long time, because it's the first time that actually the public is asked to give its own opinion with respect to investment agreement. The first public consultation was launched in January 2014, and it was and the Commission embarked on this kind of experience in the context of the transatlantic deal, and specifically the idea was to understand whether, according to the European citizens, the deal between the US and the EU was indeed moving towards a right direction, was indeed reaching an acceptable balance between the right to regulate and the protection of investment or not. I won't have time to go into much details, but it suffices to say that the Commission has mobilized civil society to unprecedented level, because it received nearly 150,000 replies. It's not a one-standing experience, but we also have, for example, more recently, another example of another European Commission public consultation in the context of the creation of a multilateral court for the investment, which was launched, if I'm not mistaken, at the beginning of January 2016, and is now closed. All the reports, all the results are available online, and are freely accessible and available to be downloaded. Lastly, another interesting point at treaty-making level with respect of transparency is the fact that the Council negotiating mandates have been declassified and have been made available online. Now, these negotiating documents are important documents because they contain the instruction under which the Commission is empowered to conduct the negotiations on behalf of the European member states. So these are important documents because they contain the guidelines the member state sitting in the Council has given to the Commission and basically explained the Commission in its line of action during the negotiations is doing what the member state have told to do. And that is also probably the reason why member states have been quite reluctant to release this document, and it has taken a while to actually declassify this document and make them available online. Now, I will have regrettably to skip this post-settlement transparency, and before concluding, I'd like to say a few words about the Brexit negotiations. Now, according to the terms of reference for Article 50, negotiation between the European Union and the United Kingdom should be kept in a transparent manner. However, as Frank Sinatra used to sing, the European Union and the United Kingdom are implementing this transparency, each of them in its own way. This means that while the EU is seeking to reach a maximalist approach in favor of transparency, the United Kingdom, is taking a more nuanced position with respect to transparency, with the UK Prime Minister having even declared that the United Kingdom would not be running a commentary on the Brexit negotiations. Now, why they assume different position? Because basically the rationale behind each position it's different, and also because there are different needs they need to respond to. So for example, in terms of legitimacy, while for the EU, transparency is indeed a tool to increase the legitimacy and also to put the European citizens in the position to taking part in the decision-making process and also to a certain extent influence the decision-making process. This is not the same for the United Kingdom, where in fact the legitimacy source for the Brexit negotiation has to be found in the 2016 referendum, which actually in which actually the British people have decided to leave the European Union. Also, in terms of unity, while transparency in the context of the European Union is indeed a tool, a means to strengthen the link between the European institution and the European civil society, by which also enhancing legitimacy. This is not the same for the UK, for example, because actually too much transparency risks to reach the opposite effect, because it's likely to lead toward public mistrust, because the public will be put in the position of actually understanding that probably the UK line of action is weak and that strategy is not as strong as the one put forward by the European Union. So there are different rationales moving the European Union on one side and the United Kingdom on the other. Now, it seems that recently the United Kingdom has slightly changed its position, and it seems to be more inclined to follow the EU line of action. So, for example, it has started to setting up its own website dedicated to the Brexit negotiation, where we can find some position papers, some speeches, announcements, and also the biography of some of the civil servants actually serving the Brexit negotiating team. But still, we are not where the European Union is. So, to conclude, is the European Union becoming a standard setter with respect to the principle of transparency? Well, we would like to say yes, but probably the most appropriate answer at the time is that it's too early to predict whether the EU is indeed becoming a global standard setter with respect of the principle of transparency. However, it's important to note that, for example, the European Union is already influencing some of its partners, and this, for example, is the case for Japan. Of course, it's not the case of Canada and the US that came with quite strong background and quite strong position in respect of transparency. But still, the fact that the European Union has been able to make available online even just certain chapters of the European-Japan Economic Partnership Agreement is a signal that the EU is already somehow influencing other partners, such as Japan, that have been more keen to confidentiality and have always been quite reluctant in respect of transparency. So yes, the EU is gradually influencing other partners and is also gradually probably becoming a standard setter. It's too early to provide a definitive answer, but in principle there are some signals like the carrying out of these consultations, and that has been, for example, also adopted in the context of NAFTA, but we are clearly not there yet. Thank you very much for your attention.
Thank you very much. Hold your horses on the questions for now. I pass the floor on to right-hand side. Gerald Conway.
Yes, maybe I can take this.
Brunel University is in London.
Okay, so the topic of my paper is going to be the idea of fundamental rights and values as an aspect of TTIP and Brexit. And what I'm going to do is explain a little bit the background to the relationship between fundamental values and the internal market principles in EU law, and set some context about that, and then to, if you like, comment quite briefly at the end, given the limitations of time, on the TTIP and Brexit processes. So firstly, I'd like to just give set some context about international trade and the debate on free trade. We think of free trade as something that's axiomatically valid. And today there tends not to be a great deal of debate about the merits and the virtues of free trade. The advocates of free trade have been successful in establishing free trade as a sort of standard normative principle in international economic relations. Now, historically, of course, trade was much more localized, was much more regionalized, and global free trading as a sort of a system of global free trading, or global free trading as a norm, is a relatively recent development. It's really only something that happened in the 20th century. Indeed, in development of European empires, of course, trade occurred without really any regulation, any systematic regulation. But the idea of a normative framework, of a standard global framework for free trade, is really something that's emerged quite recently in history, and really something that has emerged post-World War II. Free trade was a key political debate in Europe in the 19th century, especially in the United Kingdom, and it played an important role in the relations of European states with their colonial possessions, and also played an important role in a sort of process of competition between these colonial powers. Was a key element in European politics for a long time in the before, say, the second half of the 20th century. The idea of economic unions, of free trade unions, of customs unions, it started to become a more, if you like, systematic principle in the 19th century, I suppose, with, for example, the Zollverein, the union of the trading area of the German states. Yes, with the trading area of the member states. or the states of the German territories in Central Europe. So the EU was really at the forefront historically of a comprehensive and systematic notion of free trade. One of the striking features of the EU framework, as it was agreed in the 1950s, is just how comprehensive it was relative to historical developments prior to that. Competition law really only started to emerge in Europe in the late 19th to early 20th century. And yet by the 1950s, we find this very and still comprehensive framework within the EU treaties. So I think it would be fair to say that the EU has, from its beginning, been a leader in the idea in systematically developing a framework of free trade. And of course, within the EU, the two key principles of free trade, we don't call it free trade within the EU anymore, but the principles of freedom of movement and the principle of undistorted competition. And these two pillars make up the internal market, which notwithstanding all the developments in competence within EU law, especially from the Treaty of Lisbon, as our first speaker talked about, for example, the internal market is still the framework, still the core framework of the EU. And just speaking from the point of view of the United Kingdom, the internal market is really what the United Kingdom signed up to in the 1970s. In the 1970s in the United Kingdom, what is now the EU was commonly referred to as the common market. That's what the UK understood EU membership to be about, essentially. And I think that's still largely the case, because for many of the newer areas of cooperation, the UK has opted out or has modified its involvement. And of course, in this room, I would think that a majority of people would be disappointed at Brexit. But if we step back and think about it, if the EU is going to continue on the process of integration, it's likely that the UK would have been in a position of continually opting out and modifying its participation in the process. And would that have been altogether desirable from either point of view, given that the UK's involvement has basically been in favour of, okay, this free trade framework, this internal market framework, but not necessarily all the other move towards a more kind of federal solution in Europe. Fundamental rights and free trade are not very often discussed. I think free trade and trade issues tend to be seen as sort of technical economic things, not necessarily to impact directly on rights issues. And of course, within thinking of rights more generally, socioeconomic rights are seen as a sort of later generation of rights, something to be concerned with when more fundamental civil and political rights have been secured and entrenched. Rights itself is a whole important area of legal philosophy and debate, and there are different understandings of rights within legal philosophy. For example, we have the notion of rights as a special type of interest, but not necessarily some fundamentally distinct type of legal interest, as opposed to a more differentiated approach to rights, a status conception of rights, which would contrast rights with more generic, less normatively important legal interests. And one of the interesting things about ECJ case law on the relationship between the internal market and fundamental rights is that the court has not really systematically, or not systematically, but has not really established any kind of normative preference for fundamental rights over in the internal market. Quite the opposite. If anything, the court tends to see the internal market principles in fundamental terms. And of course, you have the well-known cases of Viking and Laval, which subordinated the right to strike. Notwithstanding, there's a particular competence issue in that case. The court arguably over-interpreted the EU's competence in that case. But apart from the competence issue, the question arises as to the priority to be had between a socio-economic right, like the right to strike, and the free movement principles. And in that case, the court established that free movement principle was more important than the right to strike. And so what this suggests is that fundamental rights within the EU have to be understood as not something that we might think of at national constitutional level as having the highest importance, but as something that must fit in within the framework of the internal market, and that the internal market is treated as having some kind of fundamental structure itself. And I think this is apparent in the Brexit process, at least rhetorically. The EU Commission and Commissioner Barnier have been very insistent on the special status to be given to free movement and on the very limited scope for exceptions to free movement. You're either in the internal market or you're not in the internal market. And I think that that tendency to conceptualize the internal market in fundamental terms, as opposed to a more traditional sort of national orientation of fundamental rights as having some kind of special status, it is reflected in the Commission's approach in Brexit and its reluctance to accommodate the idea of partial access to the internal market, at least at a rhetorical level. Now, I think you can draw a contrast between the Commission's sort of rhetorical insistence on the integrity of the internal market in the Brexit process and the reality of the flexibility of the EU's approach to third countries and to trading arrangements with third countries. The EU has lots of trading arrangements with third countries. We've heard about them during previous presentations. And of course, there is flexibility in that sphere. So I do think that the Commission, I suppose, is adopting a negotiating tactic of insisting on the integrity and almost the absolute nature of its own starting point of full participation in the internal market. It's either all or nothing. I suppose that perhaps is a natural negotiating tactic to some extent, but I think within EU law and in the EU framework, it's more than a negotiating tactic. It's it really does reflect the notion of the internal market as this fundamental structure that should not be fundamentally modified. And Professor Bionda yesterday discussed the issue of state aid and the role of state aid in the UK following Brexit. And I think his comments and reflections on it indicated the difficulty that the EU would see with any substantial departure from the UK from EU state aid principles. And it is a surprising aspect of EU law and politics that the EU has been so successful in removing from public debate the idea of the state as a strategic investor in national economies, which is really what the EU has done through its state aid rules. And it has marginalized debate about the strategic role of member states in developing their national economies to a largely technical issue of rules on state aid. And I think myself that in the United Kingdom will have difficulty with accepting the state aid framework as it is, as an outcome of the Brexit process. And I think that's an area where perhaps there will be more tension in the negotiating process. I'd like to finish by just making some comments on TTIP. I have to confess that I'm not a researcher in international trade with any consistency. I occasionally do research that's relevant to it, and I'm not an expert in international trade. And so I'll be careful in what I say, given the great expertise and authority, for example, of Professor Cottier, as was apparent yesterday. But I have read some of the documents on TTIP, and one of the interesting things about free trade relative to EU law is the fact that although there's different terminology used, fundamentally the issues are the same. And it can be very helpful to have studied EU law first and then to move into the area of free trade because, for example, some of the terminology of technical barriers to trade, phytosanitary measures that we find in international trade law would all fall under the one category of derogations within EU law. And so it isn't that difficult really to move from the EU internal market framework to international trade once you do that kind of translation work between the differing terminology. But just looking at the TTIP documents from the Commission, you can see there also a certain insistence on the standard EU framework and the tendency of the EU to export its norms within the TTIP process. At one point, there's a 15th report of the Commission on TTIP, which is quite recent, I think late 2016. And at one point, the Commission kind of quite openly and quite frankly says that the only way of achieving agreement will be harmonization with EU law, which is basically excluding much scope for negotiation, at least on that particular aspect. And so I do think the EU is engaged in the process of exporting its own normative framework, and that's normal. That's what happens in international treaties and agreements. But the reality is, of course, that there has to be some compromise. The EU cannot simply impose its own internal market framework onto other states. So there is compromise, and I think that that's something that will also be seen in the Brexit process. One of the comments that was made in the same documents was the possibility of involvement of US representatives in the development of European standards in the area of trade. And so I think that reflects a kind of a practical dynamic of the EU's interaction in trade, which is the role of kind of peer influences, of social networking, of expert networking in the process. And I wonder, would the involvement of US representatives in setting European standards really amount to US influence on European standards, or would it be a process by which the EU could influence US representatives? And I don't know what the answer to that question is. I'm sure it would be a very interesting practical or empirical study to see the process and the influences that take place at different stages of the process, and to what extent either party is successful in exporting its own norms into the process. So I think these are important issues within both TTIP and Brexit. The EU is coming from it with a very strong ideological commitment to its own internal market. But I think the reality is that there will be compromise, which is already reflected in the EU's agreements with third states, its existing trading agreements with third states. And so I think it'll be up, I suppose, in a year or two, we'll be in a better position to see exactly where the compromise was struck and what are the implications then for the EU internally. Will the EU succeed in kind of sticking very closely to its own sort of fundamental structure, the internal market? Or will the TTIP and Brexit processes see a certain potential for compromise on those principles, and will that have any relevance to future EU internal practices? Will member states start to say, well, look, you compromised with in these various areas with Brexit, with TTIP, why do we have to have this very rigid framework internally within EU law? And I sort of accept it as something that's fundamentally given and cannot be questioned or debated. So what way will the process go remains to be seen. Thank you.
You ended with some questions, so maybe we can think about that during the debate, which will follow. I will now straight away, in the interest of time, give the floor to Marion Geffro of the University of Rennes, and she will be speaking about human rights in future EU agreements, lessons from past experience.
Thank you, Chair. First of all, I'd like to say thank you, grazie, merci to the organizers and the participants. Human rights and trade. There are two things we'd be tempted to oppose, or at least keep separated, because they just don't seem to go along. It is a well-known fact that the rationale behind free trade does not mind much human rights abuses when it doesn't encourage them. But what if the European Union, if not the idea that despite differences, conflicts, contradictions, a way forward can always be found? In this context, be it schizophrenic or idealistic, the European Union chose to try its best to make free trade and human rights go hand by hand. This paper aims to discuss how the EU tries to find a balance in its agreements between the promotion and defense of its values, in this case human rights, and its less idealist interests, namely trade-related ones. My analysis will be centered on the instruments most well known in this field, the Human Rights Clause. I'll say HRC now for the sake of time. I intend to argue that although it is a very important tool, it must not be, as we say in French, the tree that conceals the forest. That is to say, prevent us from seeing the bigger picture and the other things the EU could make a better use of to promote and defend its values, human rights and more, environmental ones, for example. So first, a brief history of the HRC. The HRC appeared in the 90s, but its principle and raison d'être is now engraved in the Article 21 of the TEU. The EU must promote and respect the principles underpinning its identity, human rights, democracy, and rule of law being part of it, while working toward the objectives of its external action, among which is freer trade. Therefore, unlike some of its partners and big players in the world, such as the USA, China, Japan, the EU chose decades ago to put conditions on its political and trade relations. The establishment or deepening of European bilateral relations is linked to the respect of political conditions, including the human rights. It is what we call democratic or political conditionality, and the HRC is one of the tools of political conditionality. How does it work? Well, the HRC stipulates that the parties confirm their commitment to respect and uphold democracy, the rule of law, and human rights, as laid down in international human rights treaties, such as the Universal Declaration of Human Rights. This clause is later qualified as an essential element. It is very important because the utility of the HRC depends on that qualification. Without it, the EU would not be allowed to suspend or terminate the application of the agreement in case of violations of human rights, because it would be prisoner of the Pacta sunt servanda rule. The violation of the essential element, the HRC, is considered a special urgency case in the procedures pertaining to dispute resolution in the agreement. It allows the EU to immediately, almost, suspend or terminate the execution of the agreement. Skipping that. And the important point about it is that the EU introduces it with developing or developed partners. It doesn't matter. It can be found only in a very few sectorial agreements. It's usually introduced in global agreements, associations ones or political cooperation ones. But it's surprising that it doesn't appear in sectorial agreements, considering some of them deal with human rights issues, such as the readmission agreement or the PNR agreements. The HRC doesn't appear, almost never, in the trade or investment agreements either. This is one of the HRC's first weaknesses, but not the only one. And so the shortcomings of the HRC. The HRC has been criticized since its beginning on account of its legitimacy first. It is indeed often perceived and considered as a way for EU to interfere in domestic matters of foreign countries. It has been criticized for its implementation too. It has been very scarcely used in the past and only with the ACP states, which reinforces the critique that the HRC is a neo-colonialist instrument. Furthermore, the HRC works in a very opaque way. There is no clear nor public methodology or criteria to determine when it should be implemented or not. Then the wording of the clause is another cause for criticism. The content of the clause itself is more or less stabilized, but the wording of the implementation clause, which determines in which case the HRC can be used and what sanctions its violation can allow, varies sometimes greatly from one agreement to another. I'm not going to enter into details, but one example of that is the recent strategic partnership agreement between Europe and Canada. Its conditions are draconian, so it's very unlikely to be ever used. Finally, one other weakness is the HRC is far less convincing when inserted in a cooperation agreement rather than an association agreement, because the threat to suspend or terminate cooperation activities well, it does weight not enough to influence the partner compared to the threat to suspend financial aid or trade preferences. All these weaknesses contribute to reduce the credibility and legitimacy of the clause and called for a rehabilitation of the HRC system. And that's my third point, the tentative enhancement of the clause with the double agreement system. It was first experimented with South Korea in 2010. Its purpose is to use the biggest leverage the EU has on third states, meaning those who don't want to join the EU and who are not dependent on its aid. And this leverage is trade, no surprise here. In the most advanced version of this double agreement scheme, a framework agreement dealing with the political aspects of the relation and containing the HRC is negotiated. In this framework agreement, the EU might include a bridge clause, which is linking the political agreement to present or future other agreements, namely the sectorial ones and the FTA, if it's prévu. I don't have it. Those other agreements and the FTA are called specific agreements and form part of the bilateral relationship overseen by the framework agreement. It means that in case of violation of the HRC, the EU would be allowed to take measures affecting the specific agreement, meaning the FTA, to suspend or terminate its application partially or in its entirety. This system enables the EU to negotiate both a comprehensive cooperation agreement dealing with political matters, human rights, for instance, and an ambitious FTA unpolluted by political consideration, and it is something that the partners usually request. The USA, Japan, they don't like to mix political and trade things in the same agreement. After South Korea, the EU chose to enforce this system in the Asia-Pacific region, with most of the Asian partners, Indonesia, Malaysia, Singapore, the Philippines, Vietnam, initially Thailand and Brunei, to Japan, to Australia, to New Zealand, and more surprisingly, to Canada. So it's a very interesting innovation, but the fact remains that it doesn't remedy the other issues we mentioned before, and it has issues of its own. Firstly, some of the old political agreements do not include a bridge clause. So it means that in the case of a violation of the HRC, we can't reach the FTA agreement. This is the case with Indonesia and Philippines. In the more recent agreements with New Zealand and Australia, for example, the Articles 52 stipulates that the provisions of this agreement shall not replace or affect in any way the dispute settlement or termination provisions of other agreements between the parties. So no bridge clause there either. Why is this a weakness? It means that the only way for a specific agreement, namely the FTA, to be affected by the HRC clause is if the EU managed to introduce a bridge clause directly into the FTA. Like I said, most of the EU partners are very reluctant to linking trade agreements to human rights considerations, so that's not going to be a piece of cake. The EU managed to do it in the Canadian case, though. Indeed, in the SPA, the only specific agreement linked to the, not to the SPA, in the CETA, yeah, my mistake. In the CETA, we have a link to the SPA. So it can be terminated if the HRC clause is violated. I can hear you thinking, Canada being a democracy respectful of human rights, mostly, is it really a problem? Well, first, the legitimacy of the HRC depends on the fact that the same things are required from developing countries and developed ones. Then, when you dig deep enough, every country has something that rather you don't look at. Canada and Australia both were reluctant to the HRC because they did not want the EU to use it to criticize their politic towards their indigenous people. EU's human rights record is not spotless either. In theory, it is possible for a partner state to use the HRC against EU. In reality, it is more likely than the partners would abstain because they don't want to bring attention on their own issues. Thirdly, as of today, there are only two essential clauses in cooperation agreements and association agreements, the HRC and the clause about non-proliferation of nuclear weapons. But we could imagine that other elements to be qualified as essential in the future. For instance, the fight against terrorism or something relating to environment protection and the fight against climate change. In that case, the ambiguous position of Canada on controversial shale gas extraction, I knew it was going to be difficult, could be discussed with more leverage on the EU's part. Finally, there is the issue of precedent effect. If the EU compromises with Canada, Australia, or New Zealand to soften the HRC, why would not Japan, China, India, or the USA get special treatment too? The double agreement system and the HRC would only be drafted as at their maximum scope in agreements with minor partners. So, as we said, the HRC is very rarely used and its scope is quite limited. Skipping that. But the real issue is that while the HRC gets most of the attention and is showcased as the guarantee for human rights by EU institutions and mostly the European Commission, other tools and mechanisms are left in the shadow. For the sake of time, I'll spare you the next part and just skip to the instrument which is the most interesting for me. My personal favorites. It's the pre-conclusion conditionality. It is not an official name, it's how I call it. The EU did use it before its enlargements, for example, demanding that its candidates enhance their respect for human rights before joining the EU. More recently, in the EU-Japan FTA negotiations, the EU prepared a list of around 30 non-tariff barriers that Japan had to lift, or at least take steps to remove, before the FTA could advance and be concluded. What is it that would stop the EU from doing something similar in the human rights context and other values? The EU could demand that a partner satisfy a few conditions, for instance, ratification of international human rights treaties, or better implementation of the IWO treaties, or, let us dream, a moratorium on death penalty, before the conclusion of an FTA. Leaving apart the issue of the soft power of the EU, its only real leverage is trade. So why not use it to its fullest, especially when trade should be supporting EU values if there is any truth to Article 21 of the TEU. In conclusion, torn between its will to be seen as a pragmatic international player that would be more than just a trade partner and its attachment to its principle and identity, the EU often loses credibility by acting erratically, sometimes following its moral values and often submitting to market values. Thank you.
Thank you also for sticking to time. More, you even were shorter than you intended to be, so thank you very much for that too. I'm sure there will be lots of questions. Without further ado, I give the floor now to Judicael Etienne. By contrast to the previous speakers, he's not a young researcher. He's now part of the legal service of the European Parliament, although he was a researcher and lecturer before. So we're very pleased to have this practical insight at the very last moment of the conference as well. The title of his paper is The State of the Art and the Future of the EU-US Relations.
Chair, and I would like, of course, first of all, to thank you, Professor Rossi, and louder, yeah, is that okay now? To thank you for giving me this opportunity to speak today, but most of all, for giving me the opportunity to listen to all of you, because the workload makes it not often possible to step back a bit, take distance, and put things in perspective. So this was extremely valuable. I have a lot of ideas. We don't have a proposal for a trade act yet, but I can convey the message. TTIP is not on my desk for some time now. The folder is in the drawer. I was not expecting to take it out anytime soon until we got in touch about the conference. What is on our desk in the Unit for External Relations in the legal service currently is mostly a series of legislative files that are very much related to the conference topic. We have worked a lot until last week on two big files. It's the files amending the basic anti-dumping regulation, two parallel files. One is in force already, the second one will be adopted in Council next week. It's been a question of values and trade a lot in these files mostly because Parliament wanted to introduce in our basic legal framework on anti-dumping, to introduce values, namely standards on environmental law and standards on labor law as criteria to determine the dumping, to identify or to assess the injury to the EU industry, or to determine the dumping duties. We have had a clash with the Council. It's been a harsh battle that Parliament won, thanks to mainly the delegation of Italian members in the Parliament. It was first a battle of Italy in the Council that Italy did not manage to put forward, but then in the Parliament we made it to advance. It's, in my view, major step in the area of trade. We can talk maybe a bit more about this in the discussion, or bilaterally with two speakers who addressed labor and environmental standards. So we had that, we just finished. We have all the legislative files coming. We have started some of them. We have proposals from the Commission on a new instrument for screening of investment in the EU. We have a proposal on a trade regime for the import of cultural goods. And we have a proposal, it's an old proposal that we are going to take back of the drawer also. It's the modernization of our instrument on public procurement. This is more or less what we have now. We have no pending case because Parliament decided that it was not in its interest to submit observations in Opinion 117. So we did not submit written observations. So for now, we mostly work on these legislative files until we probably get questions on free trade agreements that are going to be in the pipeline in view of the conclusion. I would like to start the presentation, and not to worry, I will stick to the time. I can sum up the first part of the presentation to adapt, but I would like to start quoting a document which is the joint statement by the 81st Transatlantic Legislators Dialogue meeting, which took place last December, 5th of December 2017. What is the Transatlantic Legislators Dialogue? It's a meeting, periodical meeting, of a delegation of members of the European Parliament together with a delegation of the US Congress. This meeting addresses subjects of common interest. There are subject matter meetings and there are general ones. This one was a general one. And we have this joint statement in 8 pages, and we have a very short paragraph of 5 lines on trade. I would like to quote it because it's interesting in light of the latest developments. So the delegation says, we agreed to explore ways to further deepen EU-US trade and investment relations, taking into account the common ground reached during TTIP negotiations. Fine. We confirmed our belief, shared belief, in a rules-based, open and non-discriminatory multilateral trading system that plays a crucial role in promoting global economic growth and sustainable development. We also agreed to intensify our efforts to work together to address trade barriers imposed by other countries, particularly China. This, in light of the recent developments, sounds almost surreal, and this is a bit the outline or the idea that I would like to look into with you, is to confront these two events. It's not October 2014, the adoption of the Council directives, it's 2013. October 2014 is the publication of the mandate or directives for the negotiation. 2013-14, we have the most ambitious trade agenda ever in a bilateral pattern. 5 years later, in March 2018, we have what I would consider as the most offensive trade move that the EU ever faced. In 5 years, we then moved from this ambitious agenda to the need to address these measures of March 2018. So the question I would like to look into and to submit to you also is the following one. Is in the end this move maybe the beginning of a new beginning? Maybe we will mention the fact that there are discussions ongoing between the Commission and the US administration. Is that maybe the basis, the new common ground for resumption of negotiations? Maybe not tomorrow, after tomorrow. Negotiations on what? On a TTIP, on a medium TTIP, small TTIP, XS TTIP, or another FTA, we will see. But we will try to give some elements of answer. I will skip some slides here. The idea is to look into the latest developments under this non-preferential trade relation and then look into possible steps towards preferential trade relation. We know that we trade under WTO law. There is no free trade agreement between these two major trade partners. Under these non-preferential trade relations, you know, so that we have recurring divergences. In the left column, what you see is just a selection of issues, topics. In the left column, what the EU doesn't like. In the US, in the right column, what the US doesn't like in the EU. We don't like the American Act, Jones Act, concerns maritime transport. We have issues with SPS measures, of course. The US doesn't like our tariffs on cars. We have this now this move by the US on table olives from Spain, alleged subsidies according to the US authorities. And then the US doesn't like either or steps towards taxation in the digital area. Some of these divergences, of course, lead to disputes. These are numbers on disputes that we've had with the US. We currently have 6 offensive ongoing cases in WTO. Offensive means it's the EU complaining against the US. 5 defensive, so 11 ongoing, but that includes disputes that are at the step of the compliance. No, most importantly, and that's what I would like to develop a little bit now, is this move in March this year of the US President concerning, as you know, imports of steel and aluminium. We have 2 presidential proclamations of the 8th of March and then a third one of the 22nd of March. The 2 presidential proclamations of 8th of March, they can be summed up in 3 points. We have then this measure to impose 25% duty ad valorem on imports of steel and 10 on imports of aluminium. But then we have 2 possibilities for exemptions that are conditional ones. The first one is a possibility of exemption for countries with a security relationship if, after discussion, satisfactory alternative means can be found with the US to address the threat to the US national security. Second exemption, it concerns Canada and Mexico under the NAFTA, if Canada, Mexico, and the US find common ground to make some moves toward changes to the NAFTA. On the 22nd of March, new presidential proclamation exempting indeed some third countries and the EU from the measures. It's the EU, Australia, Argentina, South Korea, and Brazil. So until now, we are exempted from these measures until the 1st of May this year. The EU reacted promptly in 3 strands. It's the 3 measures that the Commission prepared very quickly. The first one being the possibility, and this is still a possibility, to launch consultation in the WTO, to launch complaint to file complaint in the WTO if the measures take effect. It's not the case because the measures are suspended, as we know. Second strand, the Commission has prepared a set of rebalancing measures, retaliatory measures if you wish, but under the safeguards legal framework, we call them rebalancing measures. Still not in force either because the measures are still suspended until the 1st of May. But the Commission released already on the 16th of March a list of products for consultation so that EU stakeholders can comment on the opportunity to target some products, imports from the US. Third strand of the reaction is, and this is already now the case, the Commission has launched our safeguard procedure on the 26th of March with the notice of initiation, with the idea that, of course, the measures might cause diversion of trade in steel and aluminium, diversion to the EU, diversion of imports, so that the Commission has started this procedure under the framework of the safeguards. How can we assess very quickly? It's a first assessment of these measures, and then we will see to what they could lead. How can we assess them? There are 2 possible prisms or framework for analysis here. It's the Article 21 of GATT, it's the national security exception, and there is a possibility also to consider the measures through the prism of safeguards. In other words, either under the national security exception or under the prism of the safeguards, how can we assess these measures? It's not an easy exercise because the US is not relying on any legal framework under the WTO. It is only relying on domestic law, which is Section 232 of the Trade Expansion Act. So it is our perception that the measures correspond either to an abuse of the national security exception or correspond to illegal safeguards. China is of the same view and considers the measures as illegal safeguards. China has already launched a complaint in the WTO, and we already have the first letter of the US responding to China's complaint. China then relies on the framework of safeguards, and the US repeats that it is not acting in the framework of safeguards, it is acting on the basis of Section 232 of the Trade Expansion Act, no mention of WTO law at all. Is it an abuse of Article 21 GATT? Most likely. It has a very limited scope. The material scope application of Article 21 is limited to trade in fashionable materials, to trade in ammunition, or to situations that correspond to a situation of war. I have read and heard that the scope of review, and the margin of dispute settlement bodies in WTO would be limited in the framework of Article 21. We're not going into details here, but I do not share this view that the scope should be limited. Problem is that if we look into the measures through this framework of Article 21, it does not allow for taking immediately retaliatory measures against the US measures. We would have to wait until we have a decision rulings by the dispute settlement body and that the US does not comply with the recommendations, after which we can adopt measures of compensation or suspend all concessions. So this is not a very convenient framework in which we should act. Now, if we look into the measures as illegal safeguards or disguised safeguards, this is in the left column the basic legal framework of safeguards with the conditions. In the right column is the possibility for a member of the WTO to react to safeguards. There are 3 material conditions to impose safeguards. then we have conditions on the scope of the measures. They cannot be discriminatory. In other words, they have, when they are allowed, they have to target products and not imports from certain states, with possibly an exception for FTA members, but this is up for discussion. And then there are procedural requirements. If we apply these conditions to the US measures, I think that it is quite obvious that the material conditions are not met, especially the third one, because the imports of steel to the US is probably not the result of unforeseen developments. As to the scope of the measures, they are bluntly discriminatory, as there is this possibility of exemptions, and not any procedural requirement, to my knowledge, was taken in the framework of the WTO, so we are in the presence here, if we consider them as safeguards, with illegal safeguards, or safeguards in disguise that do not comply with the conditions of Article 19 GATT and the Agreement on Safeguards. If we consider these measures as safeguards in disguise, there we have the possibility to respond very quickly to these measures. This is in the right column, the framework for rebalancing measures, and the Commission has prepared this reaction, this response to tariff duties. We have in EU law, we have the instruments to be able to react to that. I just mentioned here the safeguard regulation and the trade enforcement regulation. We will not go in detail here. I would just like to mention this and then say a word on possible further steps in view of possible resumption of negotiations. So the two presidential proclamations, they leave the room open for exemptions. We are concerned with the possible exemptions under the condition, as I said, that we find alternative ways. So discussions are going on, and I would like to here quote what the Commissioner for Trade said at the last meeting of the Committee on Trade. She said, indeed, we are talking to the US. We are looking, and I quote her here, into our irritants and questions of shared interest. Irritants, we know them, we listed them in the first slides. Questions of shared interest, they are obvious. It's mostly the overcapacities in China, mostly in steel, and the Commission then commits, together with the US, to work and to reinforce the work in what is called this Global Forum for Steel. It's a body that was, or an initiative that was taken under the umbrella of the G20, which is now hosted by the OECD. The Global Forum on Steel has adopted a roadmap to progressively phase out subventions in the steel sector, and then the Commission and the US have committed to work harder in this. What is the legal basis for the Commission to talk to the US now in this very specific situation? The Commission is empowered to represent the EU, we know that, but we know also that this power has limits. I just mentioned two cases that illustrate these limits. What could be the outcome of these talks? We don't know, because we don't know exactly what the Commission and the US administration are talking about, but what is for sure is that whatever the outcome, we would need to find proper legal basis and follow appropriate decision-making procedures to implement any possible outcome of these talks. That, by the way, have to be in conformity with WTO, so no possibility to bilaterally act on tariffs. On the formal negotiations now, can this be the basis for further formal negotiations? I have listed here a list of questions. These here are questions that we should ask to ourselves in the EU, and I think that we should, before we take any further steps, not only with the US, by the way, but with any other trade partner, we should be clear with ourselves. Following Opinion 215, we will have Opinion 117 on investment. We should be clear with ourselves what we do with the scope of investment. We should be clear with ourselves what we do with dispute settlement mechanisms. We have some policy choices that were made by the Commission, by the European Parliament. We have set the bar now, which is the ICS plus in the CETA, because CETA is a dynamic agreement. We will not go below an ICS plus with any trade partner. And last point I mentioned here, it's only a selection of issues that we have in my view, to solve is also the question of trade and sustainable development. In light of Opinion 215, I have heard twice among members of the European Parliament in meetings of the Committee on Trade, I have heard them twice quoting Opinion 215, paragraph 143, where the court says that the EU has the obligation to take into account trade and sustainable development objectives. No, and I will finish with this as quickly as I can. List of questions also, or some questions that we ask ourselves in the legal service. In the case we would be in the situation to resume negotiations with the US. Article 218 TFEU envisages only the opening of negotiations, then implicitly envisages a successful conclusion that will then materialize with the signature and conclusion. But there is no mention in Article 218 of this possibility to pause, to hold, and to resume or terminate negotiations with a trade partner. What do we do? Do we need any formal step from the Council? Do we need a proposal from the Commission? This is up for discussion, also with reference to Article 218.3 and Article 17 TEU. It seems that we would need a proposal from the Commission, but I'm not sure that we need any formal step to resume negotiations or to terminate them. On the content now, and depending on the policy choices we make, I mentioned some of them. Could we continue with the directives for negotiation that we have, or do we need to update them, or do we need a new mandate for the negotiation? It is also up for discussion here, because the treaty makes a distinction between the decision to open negotiations and the adoption of directives for the negotiation. Here, the treaty does not mention that the Council acts on the basis of a proposal from the Commission. It is also up for discussion, but we have indications. It's a case on the greenhouse gas emissions negotiations with Australia. We have indications that negotiation directives do not set an obligation of result. So until we discuss, we can continue with the mandate. It is then up for Parliament and Council, when the Commission is of the view that we have achieved the mandate, to propose the signing and the conclusion of the agreement. That was it for now. Thank you for your attention, and of course we can discuss further these elements. Thank you.
Thank you very much. I'm sure many people have questions, but we do not have much time for a general debate, because we're all very interested to hear also what Professor Maresco has to say, and I know some of you have to leave. So I would now invite any questions, and you have to be very quick to raise them, because otherwise I'll start to ask questions myself. Now is the opportunity to have Professor Maresco. This is not your summary yet.
Diabolic strategy. I have a question concerning transparency. You were mentioning that the EU has changed its policy, and this is indeed very true on this particular point, because I remember in the early years that it was extremely difficult to get the text of an agreement if it had not been concluded and officially published in the official journal. But you were mentioning that now texts are published. Could you give some more clarifications what that means? Are you saying that texts are published while they are still negotiated? Or does it mean that they are published when at least the initialing of the negotiations has taken place? So this is the first question. Second question. I know it sounds nice, transparency, that it is something we should promote, etc. But on the other hand, I think it's very difficult to negotiate if there is too much transparency during the negotiations. And we also know that nothing is agreed until everything is agreed. So if we start to publish parts of what has been negotiated, while other parts are still under negotiation, then I think we don't. That's not really a contribution, I think, to external decision making. I think this will harm the EU's position in international relations, and I don't think we should really favor that very much. So transparency is fine if it is within certain limits, if the limits are well defined, and I am myself very much against fragmented transparency. So this is my question. I don't know.
Okay, that's of course also possible.
Yes, please. It's okay. It's okay. Yes, I would just like to ask the final speaker, Judicial Etienne, about how EU-US relations at the WTO are affected by TTIP. Does TTIP kind of take over from that process, or is there some kind of parallel process of relations at the WTO that impacts on the TTIP process? I'm just wondering how that works.
Yes, question at the back here. Please, yeah. Questions to who?
To Marion and to Maria Laura. All right. My name is Isabella Mancini. I'm also doing research on fundamental rights, new trade agreements. So I really liked your presentation because there were many similarities. So what I would like to ask you is, to what extent can we consider the European Union as a fundamental rights actor globally? Because, as you said, like the European Union in the past used to include these human rights conditionality clauses with developing countries, but then in 2009 it changed its policy and then it started to negotiate these human rights conditionality clauses in parallel strategic partnership agreements, which are more of a political nature, and sometimes they don't even have legal value, like you mentioned the SPA with Canada. Yeah, there is a link also with the FTA, with CETA. But at the same time, also like Laurent Bartel, he has argued that that conditionality clause is an unusual one because it provides for the termination of the agreement and not the suspension of the agreement. So it's also questionable to what extent the parties then would be ready to terminate the agreement on the basis of human rights. And then, all right, sorry. So also like in the SPAs with the other countries, like there are no really human rights clauses, and also questionable to what extent is the reference to human rights conventions really are enough in these trade agreements, because someone like Samuel Moyn would argue that these human rights are not enough to counterbalance the material inequality that might arise in these free trade agreements. And then a question to Marcedo, it's more rather of a comment than a question, and like you mentioned the provisions in the treaties on transparency. I wouldn't say that they really, I don't know, like to what extent it's questionable to what extent they would provide a constitutional basis to the external, to the external action of the European Union. So I would say they really apply only to the internal, so that's why also like the European Union changed. And then I would maybe it would be better to clarify like transparency in what sense, like transparency of the negotiations, or transparency in terms of citizens' involvement, or transparency in the text of the agreements that are published. Thank you.
Okay, I see there's no more question, so maybe I can add a little question to Judicial. Because you're part of the legal service of the European Parliament, and I know that the legal service has considered the question of whether to refer the question of ISDS in CETA to the European Court of Justice, and they explicitly decided not to do it. Can you comment on the reasons why? So that's one question, and everybody has a question now, so I would like to to ask anyone to respond. If not, maybe the question of leadership. Is the European Union a leader? That's a really a funny question, because it recalls the concept of joint leadership, and one should ask the question also, and anyone can take it, what about, where did that notion of joint leadership go? Do you want to start?
Thank you. I will maybe start with your question, the one just put on the possibility to submit to the court a request for an opinion. So when Parliament was about to give the consent to the CETA, there has been a competing resolution that was tabled in plenary, and this resolution was about to hold the consent and instead to submit to the court a request for an opinion on whether the dispute settlement in the chapter of investment was in conformity with the treaties. The resolution was not adopted. It was rejected with a broad majority because there was in the plenary no, there was of course a debate, but there was no such a big doubt as to the compatibility of the ICS with the treaty. No, we had, and we knew also that we had Opinion 117 coming. Parliamentarians knew that because it's part of the joint, well, it's a unilateral declaration by Belgium attached to the decision on the signature of the CETA. But parliamentarians knew that we would have this request by Belgium. So the internal procedure in Parliament, when we receive the notification of a new request for an opinion from the court, is that the Committee on Legal Affairs will propose to the President of Parliament to submit written observations or not. In this case, it's not such a long time ago, we wrote a letter to the Committee on Legal Affairs to explain the state of play, to explain also that Parliament gave consent to the CETA. So if Parliament gave consent to the CETA, we assume that Parliament was of the view that CETA was in conformity with EU law. The Committee on Legal Affairs voted with 10 votes in favor, 5 against and 2 abstentions, if I recall correctly, against the submission of written observations. Why? Because there was then another majority in the Committee on Legal Affairs, another majority that was aware that if we would submit observations to the court in the Opinion 117, we would have to defend the legality because Parliament voted on the consent to the CETA. So there was a majority not to go to the court because parliamentarians did not want us to develop arguments on this. On your question on WTO, Parliament is not involved in the day-to-day work in the WTO. It's the Commission, but we get debriefs quite often from the Commission on this. What I can say is that we have a very pragmatic relationship with the US administration. Of course, we have a number of cases against each other that maybe reflects also the volume of trade that we have. But we also have a number of cases where the EU and the US side with each other. It's the case with the complaints by China on our anti-dumping methodologies, and the cooperation with the US administration is very good. Now there is something else, is that there are developments in the WTO, very negative ones. There has been a complete failure of the latest ministerial meeting in Buenos Aires, where members were not even able to adopt a final declaration. And this is now an issue. We know that the US is, to say the least, lazy appointing members in the dispute settlement bodies. So we have divergences of views here. In the same time, the EU is forging coalitions in the WTO to go ahead on a number of topics, such as e-commerce, with a good chance to have in the near future initiatives such as one on the TISA, but in other subject matter areas. Now we'll give the floor to...
Yes. So about the last question, yeah, we put constitutional into brackets for that very reason, and we were just trying to analyze the legal standing of the principle of transparency. Yes, participation and transparency are different things, but in the treaty making of the European Union, there is no sharp line between them, but the distinction is quite blurred, because we don't just simply have the idea of put these European citizens in the position of being informed, but they also are given the possibility to actually participate. Probably the distinction is more remarkable in the context of the dispute settlement. As for the other question about the timeline, the European Commission released the first text of the CETA agreement in October 2014, which did contain an ISDS clause. Then we have the experience of the public consultation between January 2014 and March 2014. In September 2015, we have the release of the EU proposal, negotiating proposal for an agreement with the US, containing an IS clause and no longer an ISDS clause. Then we have the very final version of CETA, which is the one that is actually been ratified, with the exception of the investment chapter, which is actually still under adoption, released in March 2016. So there, as we can see from October 2014, since March 2016, much has changed during the process, and the fact that there is no longer an ISDS clause is also probably due to the fact that in the public consultations, the Commission received a lot of replies actually pointing to the fact that they didn't want an ISDS clause in TTIP IP. I agree with you. I mean, I'm not a supporter of transparency at all costs, but it has to have its own limit also, because I'm not sure the public, the citizens, civil society is always in the position to give the best answer ever, like the position of an ISDS. I mean, investor arbitration is not probably the best dispute settlement mechanism, but still it might be improved. So again, there might be some harm to the negotiation as long as everything is actually always released online. But there are some kind of limits that the European Commission is already actually applying, so it should be fine in the end.
Okay, Marion?
Let's go. So, I'm sorry if I didn't get your questions right because you were pressed on, but feel free to come and we can discuss this after. I guess you were talking about the Bartel's work, which I read too, and the possible redundancy of the HRC, is it? I'm not sure. I'm sorry if I'm off topic, but I did get that it was about the non-necessity of the inclusion of the clause because it would be redundant. There is a debate on this question, and I'm quietly not sure Bartels is right about this. So, but yeah, I couldn't afford the time to talk about this topic of the fact that the HRC might not be useful because the EU would be entitled, in any case, to use countermeasures and sanctions and to suspend agreements just because the human rights have been violated. And on the second question, I guess it was about the reference to the international human rights treaties. Is it enough or not? Yes, this one I got right, okay. Well, no, it's not enough. Surely it's not. It's a first step. It's the only thing the EU can do in the clause, because if the EU tries to say, yeah, you have to respect these values because they are my values, the European values, nobody's going to accept that. It is the legitimacy problem. It would be, well, it can do it with the neighborhood countries because they have this there is this pull of the EU on the neighborhood. So I'm not sure we could add any other reference in this clause anyway, because the EU is not the ONU. It's not the ONU. I'm sorry if it's not enough, but it's free.
Yes, I think one of the kind of broad or issues, kind of wide-ranging issues that is present when you talk about trade and values is the issue of specifying about values sufficiently that they're actually kind of meaningful, and that the values are not just something rhetorical that indicates, it's good for sending a signal that we are committed to certain values. It sounds good to say the rule of law, transparency, these things, and nobody is going to say, well, we are against the rule of law, we are against, well, they might say we're against transparency. Theresa May said she was against transparency, more or less, but most of the time when you talk about values, if you just talk about them at this very abstract level, it's not terribly meaningful, and countries can make some kind of vague commitment to respecting values in the future. But if we don't specify exactly, in clearer terms what they mean, then it becomes just a rhetorical thing, and it doesn't necessarily have a direct influence on the reality of things. But at the same time, I think it is important to introduce to talk of values, but it's also important to transition to kind of concrete issues. And as you say, in a clause, you can just make reference to them, but it's a first step. And it would be interesting to see the follow-up following a trade agreement about specifying values, making values concrete. The EU has often emphasized the rule of law, and indeed the WTO is often described as a rules-based system. But I don't think we should be altogether uncritical of this notion of a rules-based system when, as in the case of the EU, you have a very flexible approach to interpretation, to legal reasoning, to the use of legal principles as opposed to legal rules by the Court of Justice, and I think that's a reality that we need to talk about too. So it's not just, it sounds good to talk about the rule of law and a rules-based system, but the instrumentalization of principles in the EU is a problem, and I think it is a problem when the EU self-presents as always this virtuous actor when its own institutions and processes have lots of problems too. And we, as academics, we need to not just propagate the official narrative, we need to be critiquing the EU as well as critiquing others.
Thank you very much. So on this positive note, I would now like to give the floor to Judge Rossi rather than Professor Maresco. The reason being that there must be somebody who can introduce him comme il faut. You will?
Because I have to introduce Marc Maresco. So you can maybe... You can stay, but maybe you can... But we have no... Okay. Marc.
That's okay, but my board is there.
As you please, as you prefer. Okay.
Which the ceremony for just a few words.
No. And now we rely on the experience and also on the kindness, on the passions of Marc Maresco. Marc Maresco is an old friend of the University of Bologna, and he's also a great expert on external relations, not only theoretically, but also in practice. He has been consultant from many of many governments. And I asked him to draw some conclusion of this long 2.5 days. Thank you. Thank you very much, Mark. I know it is a burdensome task because you had to take a lot of notes. Thank you.
Thank you so much for this almost ceremonial introduction. And I will disappoint everybody because I have changed the scenario of my concluding remarks already 15 times since I am in Bologna. So I am now really reducing it to some very basic comments, really. And I think the first thing, and that's something I always do when I'm trying to work on something, is to go to the history. And don't be afraid, my historical introduction will be very, very short. But the project was conceived, the happy moment of conception of something was in 2016. And it was, the project was recognized by the European Commission as a valid one, as an interesting one. I think it was in September 2016 or October 2016. And that is a period where things are already moving very, very rapidly, more rapidly than everybody was expecting. The Brexit arrives, and a few months later, we have elections in the US, and this affects directly, dramatically, the project. And I think I put myself a bit in the position of those who were the initiators of the project. And I should have said, of course, that the initiators of the project were Lucia, Federico, and the Bologna team as such. But they are not alone, of course. They had very good other members, initiators. The University of Rennes, which is a top university for external relations in France, external relations of the European Union, and King's College London. So you have such a team to initiate a project, and then you're hit by something which you really cannot do anything. Then I think existential questions arise. What do you do with a project under the name TTIP when there is a good chance that you will never have such an agreement? So the very fact that we were able to overcome this, and I would even add to make the challenge a creative inspiration for further developing things. I think that's really quite unique. I have some experience with projects. I think many of us have experience with projects. And if external factors intervene very directly in the very essence of the project, it may be fatal. And here it was not fatal at all. On the contrary, I think I was admiring from a distance that the project did not suffer. As a matter of fact, I think it developed. That's the first thing I wanted to say. The second point I would like to mention, if you go back to the I would say the objectives. The objectives are very nicely formulated. I don't know whether you realize it in the brochure we got. The title was Legal Ambiguities Withstanding TTIP, intends to promote a large-scale legal reflection of both the existing EU free trade agreements of new generation and the ongoing negotiations on the Transatlantic Trade Investment Partnership Agreement. When you read this, And then you see what we have done here for what you have done. I was sitting only there. What you have done, all the speakers, all those who contributed in an active way. I must also say the audience. There were so many questions. It's a very interesting interaction that shows also the quality of the content, the contents. It shows there are messages. It shows that I think we were on the good track really with the project. And the project comes, we are now April 2018. We are in the hard core of the project really. It's a bit over the middle, I think, of the timeline. But it's finished, it's terminated, termination. I don't know whether it's the right expression here. In August 2019, of course, the publication aspect, the publication dimension cannot be there yet in all its formats in August 2019, but the project will be over formally, legally, I think, at that date. And I think the meeting here was in Bologna at this moment of time here was, I think, a very crucial one because I'm sure that I don't know whether I may be speaking for the whole audience, but I think we had here an extremely interesting interaction. And I would just like to maybe mention one aspect where perhaps I don't say I was not totally satisfied with the response or the interaction, but where maybe there is a little gap, but maybe it's covered in other activities because I don't see everything of the project, of course. But we had yesterday a very interesting question about the effect of the agreement, free trade agreements, in particular also TTIP agreement, on other agreements, and also in particular on most favored nations clause. I found this a very, very revealing question, which had not been touched upon before, and which I don't think afterwards has been examined. But it was the question was raised in the sectoral sessions, and probably the sectoral sessions were not the most appropriate place to raise this type of general question. Because in my own little practice of being involved now and then in consulting negotiations or in negotiations, of course, a very blatant example of, and it's not so much MFN, but it's Turkey. The EU-Turkey agreement providing for a customs union, which is, of course, an extremely exceptional objective of external relations of the EU. We only have that with Turkey, Andorra, San Marino. The effect of free trade agreements, and in particular of the caliber of we were envisaging with US, the one with Canada, etc., the ones which had been concluded already with Korea, or Singapore, etc. This affects directly, of course, countries which are in a customs union with the European Union, and this is not something which is organized in the agreement. I know for the microstates that is different, because there we have explicit provisions on the effect of free trade agreements on goods originating in San Marino or originating in Andorra, where the other party accepts that they will be considered as goods originating in the EU. But that's in the agreement. But you don't have that for Turkey. And Turkey is, of course, bitterly complaining. Maybe today Turkey is not in the best position to make many complaints towards the EU. You know, that's another story which I don't want to open at this stage of the conference. But I think the effects of this type of agreements on existing agreements with others in the world is somehow a point, and I hope it might be touched upon in one way or another in the publication which will follow, because...
seminars.
Oh, you had seminars on that as well? You see, I did not realize that. But well, there are quite a number of other things I wanted to mention. I'm already far beyond the 1:30 limit. A number of people among others myself have to take a plane this afternoon. So I'm not going to speak that I miss my own plane. But I will not go into the extremely fascinating sectoral dimension, which I really appreciate, and what I also appreciated very much was the mix of speakers. We had very experienced speakers, senior speakers. We had also young scholars who knew very well their dossier, who really were able to present an extremely complex technical issue in a way that it was understandable for non-experts in that particular substantive topic of EU law. So I think that was a very good thing you did to mix a call for papers, and you know, call for papers who respond to call for papers, never senior experts, probably, usually young experts, which is normal. And I also heard there were quite a number of them, and you were very selective, and I think that's a very good mix, really. It's an example, I'm sure, for quite a number of institutions, universities, who are involved in this type of cooperation at the level you have been able to pursue here. I come to my last point, really. It's a personal point, because I would like really to pay tribute to Lucia. We know, of course, that she's leaving Bologna.
Only in October.
I know, only in October, but it's approaching already. And that's sad for the university in a way. It's sad for academic world. But on the other hand, we also know where you go. And I think it's a very good thing for the Court of Justice to have members of the stature and level of Lucia. So it's a very good thing. We also know, and that's also a very good thing, that this does not affect the network, that will continue, and that la passation des pouvoirs has been organized and is there and is in very good hands. I see Federico sitting there, but I also know that he is not alone, that there's a whole team, colleagues, researchers, administrative staff, Oriana. Oriana always has difficult tasks and is always there for this type of project. So I think we should be very grateful to everybody, and especially the Bologna team, that all this was happening. And thanks again. Thank you. And
thank you, Mark. And thank you to you all. And I'm here just to say that we have a lunch in the next room, and you are all invited, of course.